take up the order of this honorable court, my lord.
Okay.
It may come up on Monday, my lord.
On the how many cases are there? They'll put more than go up to 70, 80 cases.
Another matter, my lord, this is for motion, my lord. Another matter.
Witness. Net I beg to mention for motion ballot on Monday, there is an urgency. I have already filed the matter. What is the urgency? The matter regarding the departmental proceeding ballot. The direction was given to complete the matter within a 30 days. Already 15 days is over. Okay. That's on Monday. Okay. Much.
Make please, your lordship. So this matter will list for admission on, can it be on Friday, lordship? 22nd,
25th.
then my lord 29th, lordship.
Okay. 29th.
Obliged.
May this lordship, with due consent from the petitioner, I beg to mention item 34.
Item
34,
34.
supply. My lord, we are yet to receive instruction. I pray for 3 weeks' time.
Who appears for the petitioner? Datta, I think you are in this matter. Pardon, madam. Item 34.
34.
Maybe 2 weeks. First, Mr. S. Datta, Learned Senior Counsel. For the request. On request made on behalf of Mr. R. Majumdar, Learned Standing Counsel, Dibrugarh University. When do you want?
After 2 weeks, in the. For,
Possibly you want to file affidavit.
if
They will file affidavit, my lord, 2 weeks.
we are yet to receive instruction also.
Fix the matter after 2 weeks to enable him to file contract.
Much obliged.
Yes, Lordship. Lordship, listing and two writ petition matter regarding to suspension
Oh,
on 26 minute.
27, 27.
Last minute.
Official lordship.
Yeah.
Which I'm praying for listing of contempt matter on Wednesday.
27.
My pleasure, lordship. Prayer for listing of one I for implement of party. Madam, I listed on 25/11, lordship.
Okay.
Obliged.
My lord, I am paying for listing of an IML, urgent IML, because your lordship is examining a matter regarding seniority dispute between myself and the private respondent. Date of joining are same and date of birth is I am senior. Your lordship has fixed the matter on 22nd for instruction, but in the meantime, I have been transferred to another school, my lord, before the matter is under examination.
That is a different matter.
No, my lord, because matter is under sub judice, my lord, they cannot, my lord, without authority of law.
You have been transferred out
Yes, my lord.
from the school.
Yes, my lord. When the
What do you want? When is it listed? The other case.
other case will be listed on 22nd of.
So we have it on 22nd. Your IA also.
Well, prior to that, my lord, the department may take any action against me, my lord.
See,
On
today's
Monday, my lord.
14th.
On Monday, my lord.
There are 3 matters, those were to be listed after the vacation.
Okay.
I pray that those may be listed as per your lordship's convenience.
29th.
Maybe, my lord. My lord, for listing for withdrawal.
Okay.
Monday, my lord.
Witness the 20th.
Admission matter, family pension matter. Maybe.
Family pension. Okay, 22nd.
May I plead your lordship? I beg to mention for listing one writ petition, lordship, 22nd for 22nd November.
Okay.
Much obliged. May I please, lordship? Lordship, I beg to mention listing the writ petition, which was last dated filed in 3/6/2024.
27th.
20.
May I please, your lordship?
Oh.
I beg to mention listing of a series of writ petition, my lord, on 28/11, my lord.
That's a hearing day.
Yes, my lord. It's in a admission stage, my lord. What is that matter about?
Madam, regarding my lord, the polytechnic, the candidates are the candidates of polytechnic assistant professors, my lord. And meanwhile, my lord, if remember, my lord, some of the candidates has been, my lord, advertisement has been issued, my lord, and it is also finalized. And during this pendency of the petition, my lord, some of the petitioners has also applied for the said advertisement, and they have 4-5 my lord, candidates has been also my lord, qualified. And the urgency is that there is an interim order also subject to the outcome of the petition, my lord.
Okay. You want it on 28?
28, my lord.
Fine.
My lord, another prayer for another petition, my lord, on 26, my lord, if convenient, my lord. 26 or 25, my lord.
25.
25. I'm deeply obliged.
Item 1 of daily motion.
Your lordship, matter pertains to the non-payment of arrears salary from November 2020 to 2022. And for last occasion, this could directed to take instruction, my lord. And already
My lord, proposal has been sent by the DU to director, my lord. But there is some documents are not there, my lord. That's why my lord, director requested the DU to submit the documents, my lord, on 4th of November, my lord.
4th of November. And has the DO taken steps?
You know, that instruction I got.
the non-royal certificate was issued by the BEO.
Second.
And that is annexure 11, page 36.
1 minute.
My lord, may pay second one, my lord, 4th November 2024.
Second,
4th November, my lord, 2024.
non-roll is already there.
Submitted by the BEO,
Where's that? Where's your non-roll certificate?
page 36, annexure 11.
My lord, they.
Okay, non-roll certificate for 2020, 24 to 25.
25.
Okay. Third, MS A. Bazar Boral and a council for the petition. MS Espitia, Learner Standing Council Elementary Education Department submits that on receipt of the proposal of error salary in respect of the petitioner written by the District Elementary Education Officer on 16 to 2023, correct?
Yes, ma'am.
The Director Elementary Education on verification of the documents found that certain documents were missing, and accordingly the District Elementary Education Officer, the concerned District Elementary Education Officer has been directed to submit the said documents. Stop. She accordingly prays for 2 weeks' time to enable her to receive instructions. Praise the Lord. Please, after 2 weeks.
So,
Lordship, it's that NEET PG matter, Lordship, and they have filed one affidavit yesterday, Lordship.
Oh,
I want to file a reply, a short reply, Lordship. Can you-
okay, Mr. D.B. Boral and the Standing Council Health Department submits that he has filed an affidavit in opposition on yesterday.
Yesterday, my lord.
Yesterday was 13.
13th.
Please to verify and place the same. He found in order. Para. Mr. MP Shamal and the council for the petitioner. Praise for.
It may be taken up on Monday, Lordship.
Monday, my lord, because my lord, the counseling is likely to start from Monday, 18th. my lord.
Okay. Praise for a short time. to file a reply to the said affidavit in opposition. Praise the Lord. This is the matter on 18th of November.
Lordship, that interim order may continue till then, Lord.
Interim order passed release to continue.
No applies, Lordship.
3.
Yes, please, the Lordship. In this matter, my lord, record is called for, my lord. Here I have challenged the dissolution of a SMDC, my lord. On the last occasions, the Lordship has called for the record, my lord.
Yes, Chishti.
Oh, yes, Lordship, the record, Lordship, I have not, I have even intimated, Lordship, it will take some time next week, Lordship. Huh? The status quo remain, let it remain. Let the status quo remain, Lordship, let it fix on.
Mr. M.A. and the council.
It will continue.
On request made by Mr. S.M.T. Chishti, Learned Standing Council, Secondary Education Department. When do you want?
8 November, no? Lordship, 22nd, 21st of Friday.
Friday is 22nd.
এখন 25 এর লগতে yes yes
This is the matter on 22nd. To enable him to receive instructions as well as produce the reports.
next item is same note
Next item is also connected, my lord, same order.
on the same ground.
Okay, 1 minute.
But here, my lord, status quo is not there, my
Status
lord.
quo order passed earlier to continue till the next.
Here is no status quo.
One status quo is established for the same cause of action.
But
Second,
there are two school, my lord. So status quo is necessary. Otherwise, my lord, in the second school, SMDC will be constituted. my lord.
it's multiple.
Because it was fixed today, to mention, I have link it with the other case, my lord, because a record is called for, my lord.
ISS already holding the charge. There is nothing to be worried.
Where is the order?
Yes.
Where is the order?
Order is at, my lord, page number 62, my lord.
Same order, Lordship. Just common, same order.
Same order, my lord.
Same date, same order.
SMDC of two schools has been dissolved, my lord. In the earlier case, it is Dolotpur Higher Secondary School, and present case is, my lord, Tintingia High School, my lord.
No. Okay. The thing is,
Inspector school is holding the charge.
My lord, the status quo.
but Mr. M.A. Hussain, let me counsel for the petition. Mr. S.M.T. Chishti, Learned Standing Council, Secondary Education, shall receive instructions
On 22nd, both
as
the
well
cases.
as well as produce the reports. List the matter on 22nd. Status, in the meantime, parties are directed to maintain status quo.
Obliged.
28th of supplementary motion.
Lordship, Mr. Senior Counsel, Mr. Ken Chaudhary is on lag, Lordship. So kindly pass over for time being, Lordship.
Okay.
Yes, Lordship.
5 of daily list. The vacation application. May I please your Lordship? In this case, I am appearing for scope number 8. Today I have filed my power lordship. Earlier, Mr. Airbuya was engaged, but he is suffering seriously. That's why I take 10 days time, Lordship, for filing my reply
In the IA,
against this petition.
My lord, your lordship earlier occasion, my lord. My lord, pass an order, my lord. We dispose of the entire writ petition, my lord. Instead of vacating because record is required as per earlier order.
Record is called for, my lord, whether record is available or not, my lord. It is the, no, my lord, it is the second time record, and the IA is pending for almost 1 year, my lord. So even the applicant is now in bedridden, my lord. He is not getting salary, my lord, and his condition is very bad, my
1 week. Can you file within 1 week your affidavit in opposition?
Affidavit 10 days, Lordship.
Let the matter come as admission. In a hearing day, my lord, your lordship dispose of the entire matter.
Only one prayer, my lord. If the next day the record will not be come up, my lord, then my IA may be considered, my lord. Otherwise, this person is suffering, my lord. He is now bedridden, my lord.
Okay, heard Mr. M.A. Hussain, Learned Counsel for the applicant. As well as Mr. A.K. Hussain, Learned Counsel for the opposite party, number one, public writ petition. Stop. On request made by MSA Fukan, N Fukan, and the Standing Council, Elementary Education Department.
I am for the phone number 8.
When do you want? 1 week time is allowed to enable her to file, to produce the records. Stop. Para, Mr. F. U. Barbuya, Council. Interest appearance on behalf of the respondent number?
8 Lordship.
Respondent number 8. In the main writ petition. And placed for how much time?
10 days time, Lordship.
Placed for 10 days time to file affidavit in opposition. Praise allowed. We'll give a date.
My lord, date, my lord, in the admission column, my lord, so that it can be disposed of, my lord. We are also, my lord, every occasion, my lord, appearing and not disposing, my lord. My friend is also suffering, it is true, my lord.
Okay, we'll have it on 28 then.
28 Lordship.
Observation we made if record.
In the admission column, my
I
lord.
will be considered. Because my lord, phone.
My,
So you get the original.
my lord. In the admission column, my lord, let it be so that you can, your lordship enter.
It's in the admission column only.
No, it is in
It's
order.
in the order.
Yeah,
Your
it's the
lordship,
file.
earlier observation was there, that
Okay,
is why.
it's the matter on 28 in the admission column.
My lord. Hello.
6 and 7. Admission, partner method.
My lord, pleases. My lord, I think the arguments are already completed in this matter, my
No,
lord.
he wanted to argue some points. Where is he? Last occasion he was not well.
Yeah, and I think I have the records with me, my lord. I have carried it twice. I can give the record, let him submit whatever he wants to submit.
No, that will not be a problem. Okay, we'll have it on Tuesday then.
My lord, the coming Tuesday,
Yeah,
my lord, pleases.
it's fine.
My lord, pleases.
Okay, none appears for the petitioner. Why not? List the, Mr. Everyday, Standing Council,
For IIT Guwahati.
IIT Guwahati. Appears for the respondents. It's the matter on 19th.
My lord, when 19th April.
19th. That's a hearing day.
My lord,
It will be better for you.
deeply obliged.
29 of supplementary list. Admission, partner method.
এখন কি দিলা এখন প্লেস করেছো কালি প্লেস করেছো না ওকে wait please so I have placed on the other date the notifications pertaining to the act of this kind of category and also the so-called report, medical report, I have submitted before this honorable court, a big list, which says that this is a list of rejection or acceptance. Now, the Lordship will today take up what is their definite case in this. What is their plea now? The state government. State government here has filed an affidavit not by the secretary or any other such officers of the state, but by the director. Lordship may take up that
Affidavit in opposition submitted by Suranjana Senapati.
Yeah.
This is, Malad, here, kindly come to paragraph 4. That with regard to the statements made in paragraph 3 of the resolution, the deponent humbly begs to state that in order to verify the extent of disability suffered by the petitioners, so as to make them eligible to appoint under the category of persons with physical disability, a medical board was constituted, and during the medical examination by the said medical board, it was found that the petitioners do not meet the required criteria of 40% disability so as to get employment under PWD category. As such, the extent of disability claimed by each of the petitioners are categorically denied by the deponent. Now, kindly come to the next page. Paragraph 8 would be relevant here. That with regard to the statements made in paragraph 9 of the writ petition, the deponent humbly begs to state that at the time of verification of documents, the PWD candidate of the petitioners were not evaluated to verify the extent of disability the petitioners are possessed. At the time of document, the only verification was done in respect of PWD certificate was that whether the petitioners had possessed such certificate or not. In other words, the genuineness of such certificate was not verified at the time of verification of documents. Now, pausing for a moment here, the genuineness of the document to be verified later on by whom? First question is, when you verify the document, what is the purpose of verification of documents? You verify it whether it tallies with the original one, whether the prima facie document which is produced cast any doubt on the genuineness of the document. Otherwise, here it is not the document as such. They want to verify the degree of deficiency. Degree of deficiency mentioned in those certificates. They do not discard those certificates saying that those certificates are not genuine, that those certificates cannot be accepted, or that those are apparently appears to be fraud. No. On the face of the law, as stands today, whether such an approach is permissible. They, having completed the whole process, well, the process started right from the day of issuing the advertisement. Thereafter, making applications, verification, scrutiny of the applications, finding out those who are eligible, who are not eligible to be called for verification, interview and all that. Whole process was taken into the logical and they all along found that these are the candidates belonging to PWD category, and therefore they were finally selected. But thereafter they say, no, we have a doubt regarding this. Therefore, we are sending them to a medical board, whether that is permissible. Therefore, they say that we are not genuinely physically obtained. Sorry, what they said, this is the not evaluated. PW certificates of the petitioners were not evaluated to verify the extent of disability the petitioners are possessed. At the time of document, the only verification was done in respect of PWD certificate was that whether the petitioners has possessed such certificate or not. That is the only requirement under the advertisement. I will take your lordship to the advertisement. They must possess one. And if prima facie it appears to be in order, then there is no question. At no point of time ever, they notified that we will verify it again. We will verify the degree of disability of all candidates who have applied under this category subsequently. We are not acting upon finally on this certificate. Then the matter would have been different. It was not there. So, in other words, the genuineness of such certificates was not verified. Then what did they do? Kindly come to 10 paragraph. That the statements made in paragraph 11 and 12 of the writ petition are wholly incorrect, baseless, and misconceived, and hence the same are categorically denied by the deponent. As regards the constitution of medical board, so as to verify the extent of disability of the candidates who applied under the PWD category, it is stated that the government of Assam took a conscious decision to sort out an effective mechanism to fill up the post reserved for PWD candidates from amongst the genuine and bona fide PWD candidates. Genuine and bona fide PWD candidates. There is no dispute at all. But how to identify who are bona fide, who are genuine? This is the question. Because you need this certificate issued by the competent authority to be produced, to possess and produce at the time of verification. That we have done. In a recent past, it has been seen that the candidates who were not genuinely physically disabled obtained PWD certificate by fraudulent means or by misrepresentation, and on the basis of such PWD certificate, they applied under the PWD category. In the recent step of referring all provisionally selected PWD candidates to physically appear before a medical board in GMCH has detected a large number of ineligible candidates. Accordingly, in the instant selection process, a similar mechanism was adopted, and with a letter dated 13/5/2022, the principal GMCH was requested to constitute a medical board for verification of the PWD candidates for the post of assistant teachers under the DEE Assam. Now again here, Mullah. This statement, very vague general statement made that in recent past, it has been seen that the candidates who were not genuinely physically disabled obtained PWD certificates by fraudulent means or by misrepresenting, and on the basis of such PWD certificates, they applied under the PWD category. In such case, some concrete step ought to have been taken by the state, issuing notifications, proper notifications, whose cases are to be re-verified, how to verify, how to detect, what type of allegations are there. Well, after all, the element of fraud, misrepresentation, is a very serious thing, and it is applicable to individuals, particularly, because it would depend on the conduct of the person concerned. Therefore, these are all individual allegations. You cannot generally apply and say that there are a lot of allegations. Who made those allegations? Against whom? How did you inquire into all this? What is the finding about? Did you thereafter take any step to issue any kind of order, office memorandum, setting a particular course of action to be adopted and followed in case of all those who have obtained certificates on online portal? That ought to have been the right course. Nothing was done. Nothing was done. Simply an allegation was made, and that allegation will also fall through, because as I have already stated, some of them have already been given recruitment in the next step. That's done. So I do not understand how the authorities has approached the whole issue. We are genuinely concerned with those candidates who are genuinely suffering from physical disability. Obviously, nobody wants that a person with less than the required percentage of disability will get into. But at the same time, this is the law. The person having the requisite percentage of disability cannot be denied on mere surmises or allegations, wild allegations made, if I may say so. These are all wild allegations. Is there any iota of evidence now placing before this court on record? Nothing. State has not dared to come forward and state before this honorable court that this is the situation we are facing, and therefore we had to undertake this kind of recourse thereafter. This is also not coming. Director has filed an affidavit. State has not filed. Director has filed that the state government thereafter took a course, and we accordingly directed the principal of the GMCS to constitute the medical board. This is nobody. Director is nobody under the law. There must be a government decision. And to substantiate it, I can understand, they produced that minutes of the discussions presided by the Honorable Chief Minister. That minute remains a minute in the office file. That never culminated into an official order. That never took shape in the form of an official memorandum issued by the competent authority. So 162 Constitution will not come in here. This is not the law now. Now, kindly come to next page 250. They have shown it. This particular paragraph 10, the next second paragraph of that particular paragraph. Pursuant to the aforesaid communication dated 13/5/2022, a medical board was constituted by the principal GMC on 17/5/2022, and the deponent issued a notice dated 19/5/2022, informing the date and venue of medical examinations of the provisionally selected candidates under the PWD category. Thereafter, the said medical board examined altogether 550 PWD candidates from 23/5/2022 to 28/5/2022. Out of the total 550 candidates, 282 candidates were found to be having 40% or above disability, whereas 270 candidates were below the benchmark of having less than 40% of disability. Be it stated herein that 59 candidates did not appear in the medical examination in spite of giving another chance to attend the medical board on 18/6/2022. Hidden notice dated 4/6/2022. We have already gone through this. Reports are there. This was the course they have taken. Now, they have denied our contention. Last paragraph. The contention of the petitioners that there was no medical board and none of the petitioners were examined by any medical board is absolutely false, baseless, and misconceived. All the petitioners were duly examined by the medical board constituted by the principal GMCH with the expert, and on the basis of such medical examination, the extent of disability of all PWD candidates were identified. It is stated that the petitioners are not having the 40% disability as required to be considered for appointment under the PWD category, and hence their candidatures were rejected with a speaking order dated 29/7/2022. Kindly see their annexes A, B, C, D. A, B, C, D is the same thing that we have already considered. First is Annexure A is that notification dated 13 May 2022 after the publication of the final merit list. And and for the purpose of conducting medical examination, that a request made to the principal, that is the letter first, and then the notice setting forth the time period, the dates within which they should appear. And the annexus C is that so-called speaking order, whereby they say that all those who are in the table A are rejected. All those candidates who are in table A are rejected, which is put under challenge before this honorable court. This is on record. They have placed it with affidavit. This order was finally passed by the director on the basis of the list submitted by the so-called board, showing that these candidates are rejected. They themselves rejected that. Thereafter, this has been issued by the director. Now, again, my lord, page paragraph 12. That the statements made in paragraph 14 of the writ petition are wholly incorrect, baseless, and misconceived, and hence the same are categorically denied. In this regard, the deponent humbly begs to state that the government of Assam took a conscious decision in respect of appointments, recruitment under the PWD category to verify the genuineness of the disability of the candidates who applied under the PWD category. Since various complaints reports were received about fake and fabricated PWD candidates, same while delegation. Further, it is the endeavor of the respondent authority to fill up the vacancy of post reserved for the PWD category from amongst the genuine and bona fide PWD candidates. It has been observed that the candidates who are not genuine PWD or who does not meet the benchmark of 40% disability by dint of fake fabricated PWD certificate applied under the PWD category and thereby deprive the genuine and bona fide PWD candidates. As regards the issuance of so-cause notice to the petitioners before rejection of their candidacy for not having the benchmark of 40% disability, it is stated that such procedure would be nothing but an empty formality in view of the fact that the petitioners were examined by the experts of the medical board constituted to determine the genuineness of the disability of the petitioners. Well, their perception is basically wrong. Principle of natural justice is applicable and they cannot deny this right. This is a very valuable right. As I submitted on the other day, this certificate still remains valid. They have not cancelled it. Now, virtually, by saying this, they want to nullify it without there being a valid procedure followed, valid order passed. Mere doubt is not enough, madam. Mere suspicion is not enough. Mere suspicion, mere doubt, these are not enough. There must be some definite things, and on the basis of which some definite action would follow. Then only by giving the reasonable opportunity, you take a call. Otherwise, not in this way. Not in this way. Nobody wants that a non-bona fide candidate should come. 13. That the statements made in paragraph 15 and 16 of the repetition are wholly incorrect, baseless, and misconceived, and hence the same are categorically denied by the deponent. In this regard, the deponent humbly begs to state that the petitioners were provisionally allowed to participate in the selection process in question under the PWD category on the basis of the PWD certificate submitted by them. However, the genuineness of such certificates was not verified by the authority. In fact, the DEE Assam is not the competent authority to verify the genuineness and or the extent of disability of the PWD candidates. Obviously, they cannot do it. As such, the medical board was constituted in order to verify the claim of the petitioners that they are persons with having 40% disability. Be it stated herein that the petitioners duly appeared before the said medical board without questioning the constitution of such medical board. However, being unsuccessful in the medical examination, now they are questioning the very existence of the said medical board. It is categorically denied that the authority had accepted the PWD certificates submitted by the petitioners. Had these certificates been accepted by the respondent, the medical board would not have been constituted. So then you could have issued an order cancelling all that they are not genuine. Being the appointing authority, the DE Assam has every right to verify the genuineness of the certificates, documents submitted by the candidate along with application form. In fact, the application form, there is declaration to the effect that I hereby declare that the information submitted herein are true and correct. I understand that in the event of particulars or information given therein being found false or incorrect, my candidature for the recruitment is liable to be rejected or cancelled. In the event of my misstatement, discrepancy in particulars, if detected after my appointment, my service shall be terminated without any notice to me. So here, my lord, here, this statement they obtain from the candidates, they rely on it. This itself says that they will not interfere with the process of selection. Whatever, if they possess all these requirements, then they will be allowed to go through the whole process and final result will be culminated. Thereafter, those who are eligible, they will get appointment. But thereafter also they retain the authority to take action against them if they find that the statements so provided by them before appointment was not correct, not genuine. That would have been the right course for them. Because then in that case it would have been specific to the individuals, how they have done it, how they have procured it, who has issued this. All things would have been very subjective. This is a subjective approach to find out. But instead, you have just said, no, those selected, we are not accepting it in the name of a medical board, which has no authority under the law to overturn the decision already taken, the certificate already issued under the law. They do not have. Therefore, their whole action is contradictory. They are contradicting themselves, acting arbitrarily and denying the very fundamental rights of the petitioners.
Senior counsel, is there any provision in the Act?
Yes.
Where the disability certificate can be
Yes.
cancelled?
Yes, yes. How? If there is
How and
how to be issued, who will issue, and if denied, how to go on appeal, I am coming to it. That is why first, we are taking their pleas, and then I am coming to the laws. Therefore, I am saying, my lord, on the face of these specific provisions laid down in the law, and to see in what respect certain powers were given to the state governments to regulate this process. Within that given domain only they can act, not beyond that. Not beyond that. So, have they acted within that domain, or they've exceeded, or anything was done? Is there anything very specific that this certificate was never granted by the officers who have verified from the source? It's not there. Well, supposing a certificate has been obtained from the board and the authority granted to the joint director health of the particular district has issued. Suppose any XYZ state has granted in favor of ABC. If there is specific allegation or doubt, they have verified that no, this particular XYZ None of them issued this certificate. We have verified from them. So this certificate relied by ABC cannot be acted upon. Prima facie, we have done. Then of course, matter would have been different. It is not the case. So, my lord, going by their own statements here, few lines more. Had those certificates been accepted, the respondent, the medical board would not have been constituted, being the appointing authority. DE Assam has every, so we have read it, my lord, these clauses down below the paragraph. Last three lines, clause 13 and 14 of the advertisement dated 18/9/2022 clearly stipulate that the candidates must ensure genuineness of all information uploaded at the time of submission of the application form. It was further provided that the candidature will be cancelled forthwith. So therefore, there was another provision. If at the time of scrutiny, they find that there is something fishy in respect of certain candidates' documents, they can cancel it then and there. But they have not taken such a course here. It was further provided that the candidature will be cancelled forthwith if any kind of fraudulent discrepancy, misrepresentation of facts uploaded by the candidates is established by the approved authority at any point of time. Hence, the candidature of the candidates cannot be rejected at any. Hence, the candidature of the candidates can be rejected at any point of time after detection of the false misrepresentation by the appropriate authority. In the instant case, the information given by the petitioners about their physical disability after scrutiny by the medical board were found to be false and incorrect, and as such, the candidates of the petitioners were rejected outright. So this is, I have already submitted, my lord, totally illegal, arbitrary approach. Next 14, line about 6, the middle. The petitioners are not entitled for the relief so sought for, since they do not possess the benchmark of 40% disability to become eligible under the PWD category for consideration of their candidature for public employment. As per the advertisement in question, the respondent authorities have the right to verify the genuineness of the information provided by the candidates at any time of the recruitment process. As such, the respondent authorities had rightly verified the genuineness of the extent of disability of the petitioners by constituting a medical board so that the post reserved for the PWD candidates should be filled up by the genuine and bona fide PWD candidates. As such, the pair made is liable to be rejected. Now, this is the only affidavit. That's how this will come my reply. Well, we filed a reply affidavit rejoinder to this affidavit of the state. Notes it may find it on record. It was filed on 10/11/2023.
Yes.
Notes you got it, my lord. Well, may kindly come to paragraph 5. I will place few paragraphs from here, our contention. That with regard to the advertisements made in paragraph 4, the affidavit of opposition answering, deponent vehemently denies the same and respectfully states that the respondent authorities have no reason to constitute a medical board to verify the extent of disability of the petitioners, as the Department of Empowerment of Persons of Disability, Ministry of Social Justice and Empowerment, Government of India, had themselves issued the disability certificates of the petitioners, ascertaining that the petitioners suffer from disabilities which is either 40% or more in extent, which is the minimum criteria to be declared as a disable. Further, it is pertinent to mention herein that the certificate of disability issued to the petitioners shall be valid across the country as per the provisions of Section 58 of the Rights of Persons with Disabilities Act 2016. And the said certificates are valid for a maximum period of 5 years. So this is the provision made. Pan-India applicable. Then kindly come to 7. As regards statement made in paragraph 8, it is stoutly denies the same and respectfully states that the affirmation made by the respondent authority that at the time of verification of the documents, the PWD certificate of the petitioners were not evaluated to verify the extent of disability, quote unquote, is totally irrational and illogical because the certificate of the PWD candidates is only issued when a person is at least disabled to the extent of 40%. Hence, ascertaining the extent of disability of the petitioners is out of question. Further, the advertisement dated 18/9/2021 bearing number so and so clearly stated in the clause 16 under the conditions of recruitment that the reservation for persons with disabilities would be in conformity with the rights of the Persons with Disabilities Act 2016. Meaning thereby that the respondent authorities can only peruse the disability certificates of the petitioners issued by the concerned certifying authorities as per law, and the respondents have no right to constitute a new medical board to verify the veracity of the extent of disability of the petitioners as provided by the certifying authority of the Government of India. Also, there is no provision in law of establishing separate medical boards. Every time a person appears for appointment, despite possessing a valid certificate issued by the government themselves. Now, situation would be such that whenever a candidate, PWD candidate will apply, that in that case, invariably he must undergo another board. In all cases, that is not the law. That is not the law. Moreover, the respondent authorities have never ever nullified, cancelled the disability certificates already granted to the petitioners. And as such, there is no reason to suddenly question the genuinity of the candidates of the petitioners issued by the government certificates of the petitioners issued by the Government of India, which is granted finality in law. Now, kindly come to 9. With regard to the affirmance made in paragraph 10, the affidavit in opposition, the answering deponent stoutly denies the same and respectfully states that the affirmation that the government of Assam took a conscious decision to sort out an effective mechanism to fill up the post reserved for PWD candidates for amongst the genuine and bona fide PWD candidates, quote unquote, is absolutely absurd and bizarre, as there seems to be no yardstick available to determine the same, as not only the certifying authority but also the subsequent so-called medical board are both formed by the government themselves. As such, the contentions made is not tenable, as the government itself is really confused as to rely on which of the authorities as genuine, even though both the certifying authorities of the certificates in question as well as the subsequent so-called medical board established are both formed and authorized by the government themselves. Further, the authorities contended that the candidates had obtained their PWD certificates by fraudulent means or by misrepresenting, but the authorities never declared all these certificates to be ingenuine or took any kind of action against the issuing authority ever. Hence, the action of the respondent authority in declaring certain holders of the PWD certificates on the basis of an illegal arbitrary so-called medical board on a pick and choose basis is highly illegal, arbitrary, and bad in law. Furthermore, the affirmance that amongst the provisionally selected PWD candidates who had appeared before the medical board in GMCH, a large number of candidates were ineligible is devoid of any proof. Moreover, the action of conducting medical examination of the provisionally selected candidates under the PWD category is highly illegal and is beyond the statute. The aforesaid action would mean that the so-called medical board formed is actually a super expert committee, which is above the statutory body of medical officers. They are conducting as a super specialty body above everybody. That is not the law. It is pertinent to mention here that on 11/2/2023, an advertisement was issued by the Office of the Director of the Elementary Education Assam for filling up of vacancies of assistant teachers of LP and UP schools within the state of Assam. Several of the petitioners being eligible for the aforesaid post had applied for the same under the PWD quota. In the said process of recruitment, as well as the petitioners were directed to appear before the district medical board by notice dated 30/3/2023, bearing number such. And accordingly, the petitioners and the similarly situated candidates appeared before the so-called medical boards in their respective districts. Thereafter, the first and the second merit list were declared on 3/5/2023 and 8/5/2023, respectively, wherein approximately around 90 of the petitioners were selected in both the first and the second provisional merit list. Moreover, after the declaration of the above mentioned provisional list, the Director of Elementary Education Assam issued another notice dated 6/6/2023, bearing number such and such, directing the candidates to appear before the Guwahati Medical College and Hospital for further medical verification of the PWD candidates. Then the few of the PWD candidates were again referred to the districts of another medical verification. Districts for another medical verification. Interestingly, again, on 21/8/2023, the Director of Health Services of Assam issued a letter bearing number such and such, directing for re-verification of disability percentage of the PWD candidates by the Medical Board of GMCH, Guwahati. Finally, on 5/10/2023, the final select list was declared after several rounds of verification, and in the final select list, around 29 of the petitioners got selected and were appointed on 7/10/2023. This is, my lord, the number of petitioners who were finally again appointed in the another against another advertisement. Was appointed on 7/10/2023, who were, however, rejected by the so-called medical board established for the recruitment process of the advertisement dated 8/9/2021, that is the impugned one, for the post of LP UPTs. This very act on the part of the respondent authorities for selecting the same candidates for another recruitment process after having found them to be eligible as PWD candidates, despite having found them to be ineligible in another recruitment process based on the so-called medical board of GMCH, themselves clearly shows that the so-called medical board established by the GMCH cannot be called a medical board at all and relied on as one such so-called medical board of GMCH found the petitioners who got selected in the advertisement dated 11/2/2023 to be ineligible for one recruitment process. However, another so-called medical board of GMCS find the same petitioners to be eligible for another recruitment process. As such, the so-called medical board, on the basis of which the instant petitioners were denied their due right, is not only entirely unreliable, but also bad in law. We have given that final select list of those petitioners who were selected in the subsequent process of selection. Lordship may now turn to next page 11, paragraph 11, line about 4, fifth line. The answering deponent respectfully states that even though the respondent authorities state that there are complaints reports about fake and fabricated PWD certificates, but the respondent authorities seem to be very lax and slept over the issue, as they neither made any attempt of naming the culprits. Primarily, the medical board members for issuing fake certificate as alleged till date. Moreover, the respondent authorities never made any attempt of issuing any notice in general, asking all the PWD candidates holders, certificate holders of Assam to sit before any so-called bona fide medical board, which they could have constituted to ascertain fake from genuine certificates. Further, the statement that issuance of so-called notice to information given therein been found false or incorrect, my candidature for the recruitment is liable to be rejected or cancelled, unquote, is wrongly appreciated by the respondent authorities, as the information as to the certificates submitted by the petitioners were issued by the experts in the field and are statutorily recognized. Thus, the petitioners never provided any fake or incorrect information. Further, the statement that the candidature of the candidates can be rejected at any point of time after detection of the false misrepresentation by the approved authority is highly illegal and against natural justice, as there is no yardstick as to who would be the appropriate authority, as in the instant case, the medical boards who had issued the certificates of the petitioners were supposed to be a appropriate authority, but the respondent's authority very conveniently nullified that authority and formed the so-called medical board on their whims and fancies by suppressing the laws laid down, by surpassing the laws laid down. Thus, it is quite unclear as to which authority of the government could be considered as the appropriate authority. Thereby, the act of rejection of the petitioners is highly illegal, unjust, and arbitrary. Annexes are the same, my lord, which are they submitted. So need not, I will not take your lordship to the annexes of this. It will be a similar one. Acha. This bunch of paper, my lord, we have submitted along with our reply affidavit, is the list of the candidates who were subsequently selected.
In the other.
In the other subsequent process and who got appointed meanwhile. That is the list. Well, we have also brought in a particular fact. When we were asked to appear, as you have said, Mala, there is no semblance of any board as such. We appeared simply, one doctor asked me a few questions, noted down, okay, you go. We will issue certificate. This is what they did. And now they say this is rejected. They don't say, they say that this is rejected. Their candidates are rejected. But thereafter, we wanted to verify ourselves. We went to the doctors. They have given us these certificates. These doctors have said, no, you're genuinely having these disabilities. For example, we have given one. This is one by Shafiqul Islam. Kindly see the affidavit filed by us, Shafiqul Islam. In my file, page number is shown as 315, but it will be different in the additional affidavit. Looks you've got it, my lord?
Yes.
Yes. Kindly come to page 16, but paragraph 3.
Yes.
The deponent respectfully states that the petitioners who were denied appointment in the advertisement dated 18/9/2021 bearing number substances, despite being selected in the final list on the basis of some so-called medical board conducted by the Guwahati Medical College, have now been found to be above 40% disabled by GMC themselves when a few of the petitioners visited GMC as outpatients for treatment. The petitioners number 69, 71 and 121 who visited GMC for issues related to hearing impairment have been found to be above 40% disabled by GMC after running all the required tests to determine hearing loss on these petitioners as outpatients. Similarly, a few of the petitioners, petitioner number 7, 53, 105 and 120, who went for their treatment at Gwalpara Civil Hospital, Assam Medical College, and Medical College Hospital, Dibrugarh, Borpeta Medical College, respectively, were also found to have disabilities above 40% in their respective categories. The above mentioned actions on behalf of the respondent authorities clearly unravel the arbitrary and illegal approach adopted by the respondents towards the petitioners for reasons best known to them. Further, it is pertinent to mention herein that during the so-called medical board set up for the advertisement dated 18/9/2021, the representatives of GMC did not conduct any real test on the candidates. This is our allegation. Petitioners, as it took the GMC representatives hardly 2 minutes or so to determine any disability, whereas any test of disability, specifically for hearing impairment, takes about 30-45 minutes. It is pertinent to mention herein that there are certain candidates whose disability is apparent on the face of it. Yet, those candidates were denied appointment by relying on the so-called medical board because certain deformities are very apparent. One can see by eyes. So, nobody can again ask for a certificate. Having seen physically, one can make out that yes, he is disabled. We have given photos and all. This action has caused great prejudice to the petitioners, and this arbitrary action of the petitioners clearly shows that the so-called medical board was just a sham and nothing else. Just for so, they have held it. Now, what you will see, Guwahati Medical College Annexer 1A, hearing aid, we went through that they conducted these test documents were there. Ultimately, the Department of ENT, right ear, moderately severe hearing loss. Left ear, mild hearing loss. This is what, by conducting proper tests, they have given opinion. Yes, it appears. It's a medical college, Guwahati Medical College Hospital. Then they have prescribed certain medicines. Here, Lordship will see at annexer petitioners, one is shown a right ear 75% deficiency, left 10%. Page.
This is annexure 1B, Lordship.
1B. Next 1B. Next page.
This petitioner?
71. Petitioner number 71.
Lutfur Rahman Khan. Lutfur Khan. Right ear, his hearing loss is 75%. Left 10%. Next page, Lordship will find. Next. Audiological interpretation. Right ear. So one can profound, that term is there. Profound loss, hearing loss. They're difficult to decipher these words, but we can read at least to profound hearing loss. Hearing is very short from hearing loss. These are the test. Next page also 1C. Another candidate is disability certificate issued by the medical authority issuing certificate. Golpara, locomotor disability, annexure 2A, 40%. They have noted that
Yes, petitioner.
his petitioner number maybe 121. So, me too. You know,
Patient number 7.
Huh?
Solomon.
petitioner number 7. He is petitioner number 7. Sahalam. Yes, petitioner number 7. He is orthopedically disabled. Next is Sahidul Islam. Petitioner number 53. Petitioner number 53. He is Sahidul, a 2B. 2B, next page, my lord, 2B, annexure 2B. He is petitioner number
53.
53. Yes, Sahidul Islam. He is also suffering from 40% disability. Locomotor.
Hearing impairment.
Locomotor. Deformity. Locomotor deformity.
2B.
2B.
2A.
2A. He is 2A.
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 Locomotor.
And
2A
2B
is petitioner.
7.
and 2B is petitioner
53.
53.
Hearing impairment.
He is hearing impairment.
40%.
40%. Ah.
2C is 105.
2C is petitioner number 105. Amit Sharma, yes.
Profound hearing.
Profound hearing loss. They have noted here. Left hand column, madam. Annexure 2C.
This is Dibrugarh Medical College.
This is from Dibrugarh Medical College. Assam Medical College, that is. Left hand column, lordship will find the profound hearing loss. And one is severe
Mixed hearing.
mixed hearing loss with
Shapes. Low bed high.
low paid high something they say.
You can ask for hearing, but NTS for hearing advice.
He has been advised to go for hearing aid.
120. Medical verification and other process.
Number 3, 4. Medical board. 40%.
Better.
Mera.
Hearing is.
And lordship will find 2D and accept 2D is the petitioner number
120.
120. That was the medical board. There were 4 members. Chairman, then 1, 2, 3, 4 members. In that medical board, she was granted 40%. Bera IMC session. 17, 23. So she is suffering from hearing loss. So this shows that the reports so submitted earlier were not genuine and rather those who are not liable to be accepted. Yes, sir.
On the face of the.
এটা কোন নথি?
For example.
Well, certain things, they have been rejected. Petitioner number 2 and petitioner number
47.
47. It took a month.
47.
Because they are. Lord, you may see on the face of it appears that they are handicapped, but they have been rejected. Yes. This photograph will show. One is petition number
Two.
petition number 2, yes, and 47. What more proof do you require? Simply casting a doubt will not do. That is the position. Factual. That is a factual position. Now let us see the law. Lordship will kindly take up this Rights of Persons with Disabilities Act 2016. Huh?
One of certifying authority.
Section যেটা কই যাবা the very purpose, Lordship will see why this act was enacted, to give a fair deal to this kind of people. Because it was realized over the time that persons with disabilities, they are not getting a fair deal in the field of the state largest distribution from the state even. They are not treated equally, not in our society, otherwise also. Therefore, they are always looked upon. The legislature has to come up with the legislation to give them a reasonable share in the field of employment and in other advantages that may come from the state society. Therefore, it was done. Kindly see the very the first page. The object. An act to give effect to the United Nations Convention on the Rights of Persons with Disabilities. We are party to the United Nations Convention with disabilities and for matters connected therewith or incidental thereto. Whereas the United Nations General Assembly adopted its Convention on the Rights of Persons with Disabilities on the 13th day of December 2006. And whereas the aforesaid conventions
Yeah,
laid
reading
down,
from?
I am reading from the object of the act. First, object of the act. After the contents, your Lordship will find this.
Statement of objects and reasons.
Yes, yes.
It serves the persons with disability.
Yes, yes. Whereas the United Nations General Assembly, Lordship got it, my lord. My book also, of course, differs. My book is from the EBC. Lordship book is from Universal. So even then, it would be the same, my lord. It will be same here. So he says like, Lordship, it may be there. Whereas the United Nations General Assembly adopted its convention on the rights of persons with disabilities on the 13th day of December 2006. And whereas the aforesaid conventions lays down the following principles for empowerment of persons with disabilities. Respect of inherent dignity, individual autonomy, including the freedom to make one's own choices and independence of person. Non-discrimination, full and effective participation and inclusion in society. Kindly note, my lord. Respect of difference and acceptance of persons with disabilities as part of human diversity and humanity. Equality of opportunity. accessibility, equality between men and women, respect for the evolving capacities of children with the disabilities, and respect for the right of children with disabilities to preserve their identities. And whereas India is a signatory to the said convention, and whereas the India ratified the said convention on the first day of October 2007, and whereas it is considered necessary to implement the convention aforesaid, be it enacted by Parliament in the 37th year of the Republic of India as follows. Now, here Lordship will see the very purpose is the non-discrimination, respect for inherent dignity, individual autonomy, including freedom to make one's own choice, full and effective participation and inclusion in society, respect of difference and acceptance of persons with disabilities, equality of opportunity and accessibility, equality between men and women. All these are objects, and that's how it was made. With these objects, this act was enacted. Then Lordship will kindly come to the definition 2. Definitions. Here, appellate authority is there. Appellate authority means an authority notified under subsection 3 of section 14 or subsection 1 of section 53 or designated under subsection 1 of section 59 as the case may be. Appropriate authority, appropriate government, kindly see. Appropriate government to be in relation to the central government or any establishment wholly or substantially financed by that government or a cantonment board constituted under the Cantonment Act 2006, 4 of 2006, the central government. So, it is the appropriate government is the central government or any establishment wholly or substantially in case of central government, in case of cantonment areas, and in case of other governments, it is the central government. In relation to a state government or any establishment wholly or substantially financed by that government or any local authority other than a cantonment board, the state government. In case of those who are funded by the state government, then the state government. Certifying authority, E, Lordship will see. E, certifying authority, means an authority designated under subsection 1 of section 57. So we'll get this at section 57. Competent authority, G, means an authority appointed under section 49. H, Lordship may see. Discrimination in relation to disability means any distinction, exclusion, restriction on the basis of disability, which is the purpose or effect of impairing or nullifying the recognition, enjoyment, or exercise of an equal basis with others of all human rights and fundamental freedom in the political, economic, social, cultural, civil, or any other field, and includes all forms of discriminations and denial of reasonable accommodation. Because my case is the reasonable accommodation has been denied to them. There is a discrimination on that. This deviation from the normal process is taken only in respect of this PWD candidate. Otherwise, no. Now, skipping over others, Lordship may kindly come to R. 2R. Person with benchmark disability. Persons with benchmark disability means a person with no less than 40% of a specified disability, where specified disability has not been defined in measurable terms, and includes a person with a disability where specified disability has been defined in measurable terms as certified by the certifying authority. So certifying authority certificate, and it must be benchmark is 40%. S. That's why. Person with disability means a person with long-term physical, mental, intellectual, or sensory impairment, which in interaction with barriers hinders his full and effective participation in society equally with others. So he cannot participate equally with others. His participation, his progress is hindered. E again, person with disability having high support needs means a person with benchmark disability certified under clause A of subsection 2 of section 58 who needs a high support. Prescribed means prescribed by the rules made under this act. U. Now, with this, my lord, we will go to the section. Others, if necessary, we will come back and consider those definitions. Now, since we know already the purpose of the act, let us go to the reservation part. Special provisions for persons with benchmark disabilities, Chapter 6. Lordship will find reservation, Section 34.
Can we resume our 5 minutes?
Shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each group of posts meant to be filled with persons with benchmark disabilities, of which 1% each shall be reserved for persons with benchmark disabilities under clause A, B, and C, and 1% for persons with benchmark disabilities under clause D and E, namely blindness and low vision, deaf and dumb, deaf and hard of hearing, locomotor disability, including cerebral palsy, leprosy, cured, dwarfism, acid attack victims, and muscular dystrophy. So in all these 3 cases, 1% each. And in other 2, D and C, autism, intellectual disability, specific learning disability, and mental illness. E, multiple disabilities from amongst persons under clause A and B, including deaf blindness in the post identified for such for each disabilities. Now, kindly come to, so reservation is there, they have to follow this 4% reservation. Kindly come to section 57. 57. Here it comes to now the certification of specified disabilities. How to obtain certificate? Here it is. 56. Guidelines for assessment of specified disabilities. The central government shall notify guidelines for the purpose of assessing the extent of specified disability in a person. So the power retains by the central government. This is their guidelines. State has nothing to do. Designation of certifying authorities. 57. The appropriate government shall designate persons having requisite qualifications and experience as certifying authorities who shall be competent to issue the certificate of disability. Kindly note, madam. Who shall be competent authority to issue the certificate? This is the provision. Not all. Not each and every doctor. No. The appropriate government, in case of state government, my lord, institutions run by state government, it should be state government. The appropriate government shall designate persons having requisite qualifications and experience as certifying authorities who shall be competent to issue the certificate of disability. So district-wise, they have designated persons, doctors. One notification we have already read, which was placed by them, that bunch of papers issued by the governor in 17, that we have read. We will go to it again. That governor appointed. So they have exercised that power. They have issued that notification designating. Now, the appropriate government shall also notify the jurisdiction within which and the terms and conditions subject to which the certifying authority shall perform its certification functions. Jurisdiction is laid down how to do it. Within that jurisdiction, they will do it. Everybody within the district certifying authority has a prescribed limit. Within that, they can issue certificate. That is procedure for certification. 58. Any person with specified disability may apply in such manner as may be prescribed by the central government to a certifying authority having jurisdiction for issuing of a certificate of disability. So, here, a person who comes within the jurisdiction of certain specifying authority, he should apply. And thereupon only that authority can issue a certificate. As per, in such manner as may be prescribed by the central government. The procedure, how to issue, how to grant a certificate is prescribed by the central government. It has not left it to the state government. So regarding procedure part, that is the state government has nothing to do. They cannot issue a notification. Central government has already issued it. On receipt of an application under subsection 1, the certifying authority shall assess the disability of the concerned person in accordance with relevant guidelines notified under section 56 and shall, after such assessment as the case may be, issue a certificate of disability to such person in such form as may be prescribed by the central government. Inform him in writing that he has no specified disability. 3. The certificate of disability issued under this section shall be valid across the country. This is the specific provision. So, central government has already notified the procedure how to issue the certificate. Authorities which are designated to perform this job within which a particular limit has been specified by the state government. Applications must be made to him within their jurisdiction. They can follow the guidelines for issuance of and shall issue the certificate. If not, they will communicate, no, you do not have that much of specified disability, so no certificate is issued to you. That is their authority. But this certificate, once issued, my lord, it will have its operation pan-India. Now, the particular approach adopted by the state government is such that they are themselves doubting it for no good reason. And if he applies for some other, then if every state government approach such an approach towards this issue, the whole provision of the law will be redundant. It goes against this provision of law, cannot be allowed. Why it is applicable pan India? Why every state has not been given this authority to re-examine it? It has a purpose because this amounts to harassment again. 59, well, what the guidelines it says 56. The central government shall notify guidelines for the purpose of assessing the extent of sorry. So, under section 56 guidelines are there. Under 57, authorities are designated. Under section 58, procedure for certification is there, and this can be given effect to pan India. Now, C59, appeal against the decision of certifying authority. Any person aggrieved with the decision of the certifying authority may appeal against such decision within such time and in such manner as may be prescribed by the state government to such appellate authority as the state government may designate for the purpose. On receipt of an appeal, the appellate authority shall decide the appeal in such manner as may be prescribed by the state government. So there is an appellate authority. Appellate authority can decide the appeal, and it says any person aggrieved with decision of the certifying authority. Therefore, once the certificate is issued, if somebody is aggrieved by that, then to get it nullified or cancelled or varied, then he is to approach the appellate authority. To my understanding, this is the law. This is the law. Rules. Now, these are the governing principles of law. Let us see what the rules say framed here under. Source of power, we have seen, my lord. Now, kindly come to the rules. Rules are appended there itself, my lord, in the book. In the Right of Persons with Disabilities Rules 2017. Yes. These rules also extends to the whole of India, my lord. Section 1. This will come into force from the date of the particular publication in the official gazette. It says, Act means the right of the persons with disabilities act. Certificate means the certificate of disability issued under section 57. Form means the form appended to these rules. There is a form, how to appeal, how to issue this. Now, rule 2. Rule 18 may kindly be looked into. Will receive certificate of disabilities, chapter 7, my lord. Will come start from 17. Okay, my lord? Yes, 17. Application for certificate of disability. any person with specified disability may apply in Form 4 for a certificate of disability and submit the application to a medical authority or any other notified competent authority to issue such a certificate in the district of residence of the applicant as mentioned in the proof of residence in the application form. The concerned medical authority in a government hospital where he may be undergoing or may have undergone treatment in connection with his disability. He can apply if he is undergoing treatment, that doctor who is treating, there also he can apply. Otherwise, he can apply to the competent authority. Provided that where a person with disability is a minor or suffering from intellectual disability or any other disability which renders him unfit or unable to make such an application himself, the application on his behalf may be made by his legal guardians or by any organization registered under the Act having the minor under its care. 2, my lord. The application shall be accompanied by proof of residence, 2 recent passport size photographs, and Aadhaar number or Aadhaar enrollment number if any. No other proof of residence shall be demanded from the applicant who has Aadhaar or Aadhaar enrollment number. So this is the procedure for certification. 18. Issue of certificate. On receipt of an application under Rule 17, the medical authority or any other notified competent authority shall verify the information as provided by the applicant and shall assess the disability in terms of the relevant guidelines issued by the central government, and after satisfying himself that the applicant is a person with disability, issue a certificate of disability in his favor in Form 5, 6, or 7, as the case may be, different category of disability. 2. The medical authority shall issue the certificate of disability within a month from the date of receipt of the application. This is also a requirement. 3. The medical authority shall, after due examination, issue a permanent certificate of disability in cases where there are no chances of variation of disability over time in the degree of disability, or issue a certificate of disability indicating the period of validity in cases where there is any chance of variation over time in the degree of disability. So 2 categories, permanent certificate and a temporary certificate. If there is a chance of improvement, then in that case, yes, 5 years term can be prescribed. 4. If an application is found ineligible, if an applicant is found ineligible for issue of certificate of disability, the medical authority shall convey the reasons to him in writing under Form 8 within a period of 1 month from the date of receipt of the application. 5. The state government and union territory administration shall ensure that the certificate of disability is granted on online platform from such date as may be notified by the central government. Now it is only through online portal, not otherwise. That was the mandatory law. 19, my lord. Certificate issued under Rule 18 to be generally valid for all purposes. A person to whom the certificate issued under Rule 18 shall be entitled to apply for facilities, concessions, and benefits admissible for persons with disabilities under schemes of the government and of non-governmental organizations funded by the government. So this is for all pervasive. This certificate applies in all fields. not only in case of the field of employment. This is all pervasive. So is the importance of the certificate. So is the responsibility of the officers who are designated for issuing such certificates. It cannot be construed that such authorities will discharge their statutory powers, statutory authorities recklessly, with negligence, or in collusion with. This cannot be presumed as such. Yes, if there is specific allegations, it has to be inquired into, it has to be proved, it has to be found out, and then specific action should be taken and consequence will follow. There is another issue. But one cannot just doubt any XYZ has procured it. So going by their appearance or going by their disposition, going by their the surnames and all, one cannot be doubted that probably these certificates are issued not in proper way. So it needs to be re-verified, not on whims. If such whims are allowed, then what for this law? That is my question. That is why I am before you. Follow the due course. That is the thing, my lord. One has committed some crime. You find that he has committed a crime, okay. Take the bulldozer. Do the justice. This was the law prevailing. Supreme Court has already said, sorry. This is how did things are. That's why I am saying, my lord, this is almost of the same nature. I am entitled to certain benefits. I am authorized under the law. I have got something. And one fine morning you label me, well, you are a fraud. It is serious injury to an individual, insult to an individual, a citizen. And that too by none other than the government itself, government authorities. Which pinches the more? So, 20, my lord. Validity of certificate of disability issued under repealed act. The certificate of disability issued under the Persons with Disabilities Equal Opportunities Protection of Rights and Full Participation Act 1995 shall continue to be valid after commencement of this act for the period specified therein. Probably I can convey my feelings, my lord, on this particular law. Why these laws have been made? What is the purport of these laws? How those are to be construed? And what is the import of those provisions of law? And what is the arena left to the state government to penetrate and take a reverse decision here? It's very specific. Anything more? Okay, so this being the law, rules have made it very clear. If there is any grievance of any person, one can go on appeal. But they do not have the right of power to cancellation is not there. Now, what is the power of the government? Let us see that. Because we have already seen that it is the guidelines were issued by the central government. Process of verification and issuance has been issued by the government only to the extent of giving the power to designate and to prescribe the limit of jurisdiction of those designated officers. The power has been conferred on the state government. Government governor 17 সিহঁতে দিয়া আমি আমাৰ এভিডেন্সৰ লগত দিছো when asked by this honorable court What are the notification? Is there anything else than what is there in the law? They produce these documents. I placed it. That gazette notification, Lordship has read it, my lord. Gazette notification dated 14th August 2017.
Where was it?
This was submitted along with her. আমি দিছো নেকি ভেৰিফিকেশ্যন লগত কোৰ্টত প্লেচ কৰিছো নেকি কপি দিয়া নাই
It was annexed. It was annexed.
It was not annexed. No. কিন্তু আমি এফিডেভিট এখনো দিছিলো যে তাত দিয়া নাই নেকি No. আচ্ছা Well, that has not been placed on record as such, Lordship, but then yes, day before I placed it, Lordship has read it. It might be in the file.
Notification to
Yeah.
give to the court when they have given only.
They filed it. State government has filed these two documents. One is
It is marked as X, Lordship.
XX, yes. X. There is one communication letter to the standing council. That letter, Lordship may skip. Next is the Gazette of India. They have placed it, photocopy. There are two notifications here with respect to the Disability Act. One is the unique disability identity card portal it speaks about. That is the first notification appearing in the first page of the bunch of papers, my lord. 5th May 2021, that is. Now say that this is through the portal and there must be a unique identification number. And then next page, Lordship will find notification number HLA 997/2016/278. That is 14th August 2017. In pursuance of enactment of the Right of Persons with Disabilities Act 2016 and in supersession of earlier notification, video number such and such dated 1st of February 2013, the Governor of Assam is pleased to notify the Joint Director of Health Services of respective districts as certifying authority under Section 57, 1 and 2 of the said Act for issue of certificate of disability within their local jurisdiction. They place this, they said this is the law which is prevailing now. Because the Section 57 says that such authorities shall be designated by the state government and their jurisdiction shall be laid down by the state government. So state has done it. The certifying authority shall follow the procedure for certification as laid down under Section 58, 1, 2, and 3 because they cannot themselves lay down any procedure. So the notification just repeated that the certifying authority shall follow the procedure for certification as laid down under Section 58, 1, 2, and 3 of the said Act and relevant provisions of the rules thereunder. Rules are made by the state government. Further, the Governor of Assam is pleased to notify the Director of Health Services Assam as appellate authority for appeals against the decision of the certifying authority for issue of certificate of disability under Section 59, 1 and 2 of the Rights of Persons with Disability Act 2016. So appellate authority has been specified, appointed. This is X. Not quite it's X. That is the only thing of the government. They have not been able to place anything. There is no other notification issued covering this bill. There is no other notification ever issued by the state government for re-verification. Because they know it would be against the law. They do not have this power to issue such notification. It is for the central government. They do not have the power. Let us see rule making power, 101 of the rules of section 101. whether the state government could have made any rule under this act. Nothing kiba? 101, my lord. Power of state government to make rules. What are those fields assigned to it? The state government may, subject to the condition of previous publication by notification, make rules for carrying out the provisions of this act not later than 6 months from the date of commencement of this act. In particular, and without prejudice to the generality of foregoing powers, such rules may provide for all or any of the following matters, namely, matter of constituting the committee of search and disciplinary disability, research and disability under section 2 of section 5. And there should be a committee, advisory committee like, that is for the manner and of providing support of a limited guardian under subsection 1 of section 14, the form and manner of making an application for certificate of registration under subsection 1 of section 51, the form and manner of making an application, how to make, and form. Already this is annexed. Form is also provided under the law itself, rules itself, guidelines itself. The certificates to be provided and standards to be met by institutions for grant of certificate of registration under subsection 3 of section 51. Section 51(3), what it says, my lordship may see. Talks about the form of manner of making an application for certificate of registration under subsection 1 of section 51. 51, it says that every application for a certificate of registration shall be made to the competent authority in such form and in such manner as may be prescribed by the state government. That is the only area where form and how to apply. On receipt of the application of such, the competent authority shall make such inquiries as may deem fit. So to that extent, they can make this rule. The facilities to be provided and standards to be met by institutions for grant of certificate of registration under section 3 of section 51. It talks about, my lord, no certificate of registration shall be granted under subsection 2 unless the institution with respect to which an application has been made is in position to provide such facilities and meet such standards. That means the certifying authority must have those facilities. It is the duty of the state government. Section 51, subsection 3 says that it is required. So, rule says that the facilities to be provided and standards to be met by the institutions for grant of certificate of registration under subsection 3 of section 51. That standard must be provided. How to provide? They will make rule to that extent. The validity of certificate of registration, the form of and conditions attached to certificate of registration under subsection 4 of section 51, and this is subsection 4. The certificate of registration granted under section 2 shall, unless revoked under section 52, remain in force for such period as may be prescribed by the state government. They may prescribe a period, may be renewed from time to time for a like period, shall be in such form and shall be subject to such conditions as may be prescribed by the state government. Section 51, subsection 4. So under that, they can prescribe these rules, but here is nothing. The period of disposal of application for certificate of registration under subsection 7 of section 51. The period within which an appeal to be filed under subsection 1 of section 53. The time and manner of appealing against the order of certifying authority under subsection 1 manner of disposal of such appeal under subsection 2 of section 59, the allowances to be paid to nominated members of the state advisory, the rules of procedure for transaction of business in the meetings of the state advisory board, K, the composition and functions of district level committee, L, salaries, allowances and other conditions services of the state commissioner, M, the salaries, allowances and conditions of services of officers and staff, and the composition and manner of appointment of experts in the advisory committee under subsection so and so. The form, manner and content of annual and special reports to be prepared and submitted to the state commissioner under subsection 3 of section 83. The fee or remuneration to be paid to the special public prosecutor. Q, the manner of constitution of state fund for persons with disabilities. You can skip. R, the form of preparation of accounts of the state fund for persons with disabilities. Every rule made by the state government under this act shall be laid as soon as may be after it is made before each house of the state legislature, where it consists of 2 houses, or where such state legislature consists of 1 house before that house. So this is the law. The fact.
So the only way out for them, if they have a doubt on you, is to resort to section 52.
Section 52.
Correct?
Appeal.
No, not that. Revocation of.
Revocation of registration. Competent authority may, if it has reason to believe that the holder of a certificate of registration granted under subsection 2 of section 51 has made a statement in relation to any application form, that time, then the competent authority can look into and they can take a call. That is why I am submitting, well, my certificates are the trump card, so far I am cut. It is applicable in all fields. Unless this is nullified, varied, discarded by the competent authority which issued, competent authority by which issued it, they may cause a verification, revision, if there is specific allegation against them.
Understood.
Yes. Then only. Then in that case, how to proceed, what to be done, there must be some notifications. We do not have such notifications issued by the state government. Nothing. Therefore, my responsible submission is that when this certificate is still valid, it cannot be construed to be as not operating as a valid document because of some doubt which may have arisen in somebody's mind. The benefit which are to flow from that certificate should be given to them. And ultimately, if it can be detected, it can be proved that no, that has been extracted by misrepresentation, then in that case, action will follow definitely. In many cases, this happens, my lord, many persons get appointed into the government jobs after all verification, everything, like APSC and all, there are many cases. And subsequent verification, it is found that no, there was some fraudulent procedure adopted. And in that case, how to proceed? Those appointees were again given notice and they are taken care of. Because at that time only, the authority retains the power to act against them directly. Because they are the state authorities employees. Now, what is my position here? I am a job seeker. I have applied with all documents. You have found that this document is enough to allow me to go through the process. Ultimately, you have selected me. Finally, you say, no, we have a doubt. And then you send them, what is my option left? You ask them, you go appear before them. I have gone there. By that itself, whether I will lose all my rights? No. Because if the action itself is bad, ab initio, if you do not have this power to take, then my submission to that is only on compulsion. Because I never doubted that I will be denied. Because I never ever think that my certificate is forged one or fake one, not genuine. Therefore, and that their whole action itself proved that their action was also not genuine. It was not the cleansing of everything. No. The same authority again found some of us appointed on the same document. Yes, you go ahead. Nothing. So their own action has nullified their first action. So my response submission is, they are entitled to be considered for appointment, and appointment letter should be issued to them. But the authority will retain the right to act if there are sufficient cause, sufficient materials in their hand. They will always have that. I cannot stop them. I cannot stop them. They will always have this right to proceed against any one of them and take the call, take the final decision. They may be terminated, gone. But the ultimate benefit, how can you deny them? Article 14 will be a travesty in that case. We were given by the law, special by the parliament of the country, to give an equal opportunity so that they will have an equal share in the field of appointment also. This is a special law made. Under that, we have the certificates. This is a special law. A special consideration has been given to us. And we obtained the certificates. Therefore, we are eligible. You yourself say, we are eligible, and we are ultimately finally selected, bearing us others appointed from that list. We have been denied by citing that a report. The report is no report at all, as I have already stated, madam. A medical report should have been in the form of a medical report. That the examined, these are the tests done, these are the findings arrived at, these are the doctors who were there in the form, in the board, they have signed it. That should be the report, as I have placed it in case of these 3-4 petitioners before your lordship. That certificate is granted. This is.
You have to give me a list.
Yes.
Of those petitioners who were given the appointment.
Yes, yes.
Subsequent.
Yes, yes. We have already given it, madam. What is it like? In that affidavit, lordship will find it. Find out. Yes. That. Yes. We'll give a separate list. Separate
Yes,
list
Lordship.
with
We'll
petition.
give another list also with the petitioner numbers. However, we have filed an additional affidavit with regard to
No,
that.
no, you have given the list,
Yes,
this list.
yes, Lordship. We have
But here we don't know who are the petitioners.
we have marked it there.
There we have noted it, but then it's only a list of those petitioners who have been appointed by now that can be given to your lordship. Here we have noted it. Supposing, my lord, that page, that bundle of papers, first page, first one, Zahid Hussain Ullah, his petition number 1.
197. We can
Ah.
give it.
We have already noted the serial. We have already prepared it. We will give it formally to your lordship. Like these are all serial number of the petitioners, their name, and who got a point. Then again, next page, Atwar Rahman, Sunwar Hussain, Rahima Khatun, they were appointed. Next page also, Abdul Fazal Haq Chaudhuri, Dhruva Jyoti Deka. This is how all are marked there, but their gender category, so and so, so and so, so and so, so and so. Petitioner number has not been given, no? We'll submit it separately to substantiate. Because we are questioning the very lordship will be pleased to discard the so-called report of the medical board. It is no report at all. Lordship will see. This is a peculiar case here. It doesn't conform to any other procedure laid down or say facts really similar to others. Here, isn't it? One pocket delay. I'll place that lordship is going to the judgment, I suppose. I'll place it, my lord. Before that, lordship may kindly look. This, as I am saying, this affidavit, additional affidavit submitted by Jahid Hussain Ullah by Jutika Das. That additional affidavit 2412 page 2412 lordship's file. I placed it there before.
Yes.
So here, lordship will find this report, my lord, this bunch of papers annexers in this affidavit itself. It simply said that this is a list of accepted PW candidates for the post of regular teachers under DE Assam. That means they have accepted these candidates. It is not a report. Here they have mentioned the disability percentage, but the foundation on the basis of which this opinion was recorded, this is not before your lord. This is not coming. On the face of our allegation that no test, no examination was as such carried out.
This list which you have just handed over,
That
is in connection with this page 2420.
This is the list of candidates who were selected later on in another proceeding, Lordship.
That's right.
Yes.
This serial number 1.
Zahid Usahi has been selected, Lordship.
How do I know this?
that detailed list is placed before your lordship on that.
Serial number 1 is petitioner number 1.
Petitioner number one, Lordship.
Not serial number.
Yes,
Yeah.
petitioner number.
Petitioner number. That we have to give it thoroughly. Well, prepare koi diba, what cake dicha. Well, buji poke diba. Petitioner number 1.
It is not serial number.
Not serial number, it should be petitioner number. It will be corrected, my lord. I have seen it, but I asked them to prepare it fairly. That is why I didn't wanted it to be placed before your lordship. It might confuse. So here, this bunch of paper, this list, they call it a list showing the candidates who are accepted, and another list showing candidates who are rejected. This is only. They were not asked to issue certificates. They were asked to verify. But then at any rate, the law as stands today, as we have found it, this cannot be done by them. In the face of it, this is not a report as such. And even if it was a report, this could not have been done because law doesn't permit them. Properly constituted board and on the face of the allegations. Well, here, they say only that having learned from sources that some people have crept in by fraudulent means obtaining certificates. This is a very vague one. Very vague allegation on the basis of which the rights of these persons can be taken. Not at all. There is flagrant violation of Article 14 and 16 here. Therefore, my full submission, petition deserves to be allowed. Now, this decision, Lordship may see, I was looking for if there is any such decision which may support us. We found one of the Calcutta High Court. This was of 2023, of having some bearing of the facts here. Facts are relevant. Yeah.
You have lunch, get her some strength, then we'll.
Oblige. Oblige.
See, in respect of item number 8, Lordship, we both have decided any other day, Lordships today, so
Okay.
any other day, Lordship.
Oblige.
December first week, Lordship.
Okay.
28th November.
On request made by department.
28th November.
28.
Lordship. Oblige, Lordship.
Lordship, item number 10, 11, and 12, Lordship.
Yes.
10, 11, and 12, Lordship. These are the petition, Lordship, filed by the petitioners for regulation of their service, Lordship. In this case, our one affidavit is already there. Lordship, some developments are there, Lordship, and I want to bring those developments in record. Lordship,
Lordship, let the matter come, Lordship. Madam,
Lordship, in fact, I have informed her senior. I personally talked to her. I personally talked to her just about 1 hour ago, Lordship.
He's saying there are some objects.
Lordship.
Madam, up at 2, Lordship.
We are continuing the hearing.
Item number 9, I'm paying for some.
Dekha.
Yes, Mr. Dekha is here.
Dekha, the council for petition. On request made by NT Khatania, Learner Standing Council.
Elementary.
How much time?
2 weeks,
2 weeks time to enable him to receive instructions.
Yes, sir.
Your Lordship,
You want it out?
Yes, 25th.
That will not be 2 weeks. It will be 29. 29.
May I please, Lordship? Lordship, in regard to item number 28, Lordship. Lordship, Senior Counsel, Mr. Ken Chaudhary has left, Lordship. So, Lordship, may kindly take up the matter on Monday,
28.
18th, Lordship.
No, motion matter.
Yes, Lordship, 28.
Okay, on request by the pair of the
Lordship, similar prayer for
Oblige,
item number 14 to 19, Lordship. Senior Counsel had to leave for Delhi, Lordship.
14 to
19.
MK Chaudhary.
No, Ken Chaudhary, Lordship.
Okay, on request made on behalf of Mr. Ken Chaudhary.
I've informed Mr. Vedanta Kaushik.
For the petition. When do you want?
Lordship, next week, any day is convenient to your Lordship. It will take some time, Lordship. Any day your Lordship fixes.
25.
yeah, please, Your Lordship. Lordship, with regard to item 13, Your Lordship, Mr. B. Chaudhary is unavailable today due to personal difficulty. I've taken the consent of the petitioner, Your Lordship.
Which item?
Item 13, Your Lordship. Supply.
Request made on behalf of the Chaudhary. When do you want?
Anything next week, Your Lordship.
It's down. Okay.
Can it be 26?
Lordship, 11 to 14 to 19. 26 November, Lordship.
It's a hearing name.
Oblige, Lordship.
Sometime to file affidavit, Lordship. I have taken consent from the other side, Lordship.
24, isn't it?
24 quantum case.
One and two.
Content number. JP Promo.
All done. PTC.
Only JP Promo, Lordship.
Respondent number 2.
2
How much time?
for kindly, Lordship.
What?
Incomplete instruction received, Lordship. I need to check.
Then that may be fixed, Mala.
It's 60.
Mala.
Deeply obliged.
Oblige.
Item 29 will continue.
May I please about. Now, Lordship will kindly take up the decision, Calcutta High Court decision. Let us first see the facts and how it is relevant here. I will have to place the whole judgment so that appreciation will be in right track. The present writ petition has been preferred challenging an order dated 13 December 2023 passed by the learned tribunal in the original application number such and such, by which the cancellation of candidature of the petitioner for appointment to the post of junior engineer civil was held to be fair and reasonable. His candidature was cancelled and it was held to be fair by the tribunal, administrative tribunal. Shorn of the unnecessary details, the facts are that the petitioner is a physically disabled person with hearing impairment of 40% disability, as certified with a memo number so and so dated 19th January 2017 by a medical board at the Lalbagh Subdivisional Hospital. In response to an advertisement published by the Public Service Commission, West Bengal, in short, in the month of December 2017, being advertisement number so and so, the petitioner applied for participation in the recruitment process for appointment to the post of junior engineer civil. He emerged to be successful, and with a memo dated 1st October 2019, he was recommended for appointment by the PSC. He was recommended. Thereafter, with a memo dated 18th November 2019, issued by the respondent number 3, he was requested to submit duly filled in verification role, which he would furnished, which he duly furnished. Thereafter, by a memo dated 19 December 2019, issued by the respondent number 5, he was directed to appear before the Standing Central Medical Board, Medical College and Hospital on 27 December 2019. The petitioner duly appeared before the medical board on the same date. Upon examination, he was handed over a document signed by the board members dated 27 December. Kindly note here, it was signed by the board members 27 December 19, and a document referring him to attend Dr. D. Mukherjee for the ENT department on 14 January 2020 for verification of the degree of disability. The petitioner duly appeared before the said doctor and he was examined, but no report of such medical examination was provided to him, like ours. As the respondents thereafter, they maintained a deceptive silence. As the respondents thereafter maintained a deceptive silence, the petitioner submitted two successive representations on 8 February 21 and 12 March 21, but in vain. And as such, he submitted an application under the Right to Information Act on 19th June 2021, and he responded thereto. He was handed over letters dated 24 January 1920, issued by the respondent number 5, and a letter dated 14th October 2020, issued by the respondent number 3. In the midst thereof, the petitioner filed a writ petition during WPA substances, and during pendency of the same, the petitioner was served a memo dated 10 December 2021, issued by the respondent number 3, enclosing a memo dated 1st December 2021, issued by the respondent number 6, in which it was stated inter alia that the petitioner could not fulfill the percentage disability to avail the facilities concessions admissible to the handicapped as per Women and Children Development Notification dated 27 September 1989, and that his candidature stands cancelled. In view thereof, the writ court by an order dated 7 February 2022 dismissed the writ petitioner with liberty to the petitioner to ventilate his grievance before the jurisdictional tribunal. Pursuant thereto, the original application was filed and the same was admitted with direction upon the parties to exchange their reply and rejoinder, and pursuant thereto, the parties exchanged their pleadings. Drawing our attention to the impugned order dated 13 December 2023, passed by the learned tribunal, Mr. Sattopadhyay, learned advocate appearing for the petitioner, submits that in the medical certificate in the form prescribed, annexed at page 63 of the writ petition, it was stated that unfit on account of the percentage of the disability is 7% and not eligible to avail handicap quota. However, none of the three doctors who signed the said form was an ENT specialist, and as such, they referred the petitioner to Dr. Mukherjee, ENT department, for verification of the degree of the disability, as would explicit from the document annexed at page 53 of the writ petition. The petitioner duly appeared before the said ENT specialist on the specified dated, but no final report was prepared, and accordingly, in the memo dated 24 January 2020, annexed at page 62 of the writ petition, it was stated that previously this name is reported as pending video order number so-and-so, dated so-and-so. In the said conspectus, the learned tribunal erred in law in refusing the petitioner's prayer, stating the memo dated 24 January 2020 to be sacrosanct, though the final medical report was still awaited. Referring to the advertisement number so-and-so and the averments made in the reply filed by the respondent before the learned tribunal, Mr. Sattopadhyay argued that the certificate of disability from a medical board constituted at Government Medical College Hospital in Kolkata, district hospitals and subdivisional hospitals was an essential requirement for participation in the recruitment process. The petitioner applied on the basis of the disability certificate dated 19 January 2017, issued by a medical board at the Lalbagh Subdivisional Hospital. On the authenticity of the said certificate has not been challenged by the respondents in our case like. It is also not a case that the said certificate was obtained by practicing fraud. The percentage of disability was ascertained to be 40% by the competent medical board, and as such, there can be disputed that the petitioner was eligible to avail handicap quota, and accordingly, he was recommended as a scheduled caste candidate under PHHI quota. The Central Medical Board had no jurisdiction to sit in appeal over the assessment of disability made by the competent authority, being Lalbagh Subdivisional Hospital, as like us. Drawing our attention to the clause of medical examination in the advertisement, Mr. Sattopadhyay submits that the function attributed to the medical board was for issuance of certificates to the candidates of their fitness for government service in form prescribed by the purpose, the fitness certificate after appointment. In exercise of such jurisdiction, the Central Medical Board could not have altered the percentage of disability as determined earlier by the competent authority, as reviewable after a period of 10 years. As such, on the date the petitioner submitted his online application, which commenced from 13 December 17, he was having a certificate issued by the competent authority stating that his percentage of disability was 40%, and in view thereof, the petitioner was recommended as a physically handicapped quota candidate. He contends that in the memo dated 1st December 2021 at page 75 of the writ petition, the respondent number 6 erroneously observed that the petitioner could not fulfill the percentage 40% of disability to avail the facilities concessions admissible to the handicapped as per Women and Child Development and Social Welfare Department notification dated 27 September 1989. Referring to the said memo as well as the amendment notification dated 18 July 99, Mr. Sattopadhyay submits that in the event of any dispute regarding recognizing any person with disability under the Act or any dispute regarding the percentage of any disability as certified by medical authority, it was incumbent to the medical board to refer the matter to the appellate medical board. However, no such steps has been taken by the Central Medical Board, which has no ENT specialist. The petitioner was, however, referred to an ENT specialist, and before obtaining final report, his candidature was cancelled in a most illegal and arbitrary manner, and that too without grant of any opportunity of hearing. Such arguments as advanced were glossed over by the learned tribunal, and no finding was returned on the same. Mr. Mukherjee, learned additional government leader, appearing for the state respondent, denied and disputes the contention of the petitioner, submits that the Central Medical Board had every jurisdiction to ascertain the fitness of the candidate and to quantify his fitness percentage. In support of such contention, he has placed reliance upon Rule 10 of the West Bengal Service Rules. Drawing our attention to the medical certificate in the prescribed pro forma annex at page 63 of the petition, Mr. Mukherjee argues that the petitioner was found to be unfit on account of the percentage of disability, which was determined to be 7%, and as such, medical board rightly observed that the petitioner was not eligible to avail handicap quota. He further submits that the certificate dated 19 January 2017 at page 44 was issued to the petitioner under the Persons with Disabilities Equal Opportunity Protection of Rights and Full Participation Act 95. Thereafter, the 95 Act, which stood repealed by the Right of Persons with Disability Act 2016. Referring to Section 102 of the 2016 Act, he submits that as on the basis of the certificate dated 19th January 2017, no steps regarding employment of the petitioner was taken during subsistence of the old Act. The issuance of the said certificate cannot be deemed to have been done or taken under the corresponding provision of the new Act, and that as such the said certificate had no force on the date he appeared before the Central Medical Board. In reply, Mr. Mukhopadhyay, learned advocate, argues that in view of the provisions of Rule 20 of the 2017 rules framed under the 2016 Act, the validity of the certificate of disability issued under the repealed Act shall continue to be valid after commencement of the new Act for a period specified therein, and that as such the disability certificate was valid on the date of advertisement was published. We have heard learned advocates preparing parties at length, and we have given our anxious consideration to the facts. Indisputably, the PSC, upon consideration of all records and on the basis of certificate dated 19th January 2017, issued by the competent medical board, recommended the petitioner, after he emerged to be successful in the written examination and personality test. The recommendations memo dated 1st October 2019 reveals that the number of reported vacancies was 635, out of which there were 7 vacancies in PHHI quota. No fresh selection process has been initiated thereafter, and no amendment has been made in the reply filed before the learned tribunal that there is no existing vacancy under the PHRI quota. Same thing here. We have been recommended by the committee, the final selection committee in the select list. It has never been cancelled and no posts are still lying vacant. The perusal of the order impugned would reveal that the learned tribunal dismissed the original application, placing reliance upon the memo dated 1st December 2021, issued by the respondent number 6, being oblivious the fact that the medical examination on 27 December 2019 was not completed, since the petitioner was referred to an ENT specialist and his report was still awaited. On the basis of an incomplete report, the petitioner's candidature was mechanically rejected without any application of mind. The learned tribunal dismissed the applications by cryptic order, and the same, in our opinion, is not sustainable in law. Therefore, the court came to the opinion that there was no definite report. The report which was asked to be obtained from the specialist, that was not there. Here is the case almost similar. The report as such, as I am saying repeatedly, is no report at all. It is a list rejecting either or accepting and mentioning the disability percentage. Who found out? How found out? What was the procedure? Was there other signatures, doctors? Nothing is there. Our claim is that there was no expert, nothing, no procedure as such was ever followed. In that context, same thing here, that there was no definite opinion arrived at. On the contrary, the definite opinion arrived at and pursuant to which certificate was granted by the statutory authority, it is holding the field as on today. Therefore, my right crystallizes, still available, and I am entitled to the benefit of this. The argument of Mr. Mukherjee that as on the basis of the certificate dated 19th January 17, no steps regarding employment of the petitioner was taken during subsistence of the old act, the said certificate has lost its force on the date he appeared before the Central Medical Board, and that the Central Medical Board had every jurisdiction to reassess the fitness of the candidate and to quantify his fitness percentage afresh is not acceptable to this court. There, in that case, he obtained it under the old law. But the new law itself granted that this will continue. That point was ours. Court says no, it has no force at all. The advertisement clearly specified that the disability certificate required for participation must be a certificate from a medical board constituted at Government Medical College Hospital in Kolkata, district hospitals and subdivisional hospitals. The certificate dated 19th January 2017, on the basis of which the petitioner applied, was issued by a medical board of a subdivisional hospital, an authority competent under the 1995 Act. The percentage of disability assessed by the competent authority would not have been reviewed. Kindly see, note, my lord. The percentage of disability assessed by the competent authority would not have been reviewed on or altered by the Central Medical Board through the remarks made on 27 December 2019. Same thing is here. They could not have reviewed it because they are not the authority. They cannot sit over the decision of the appellate, the statutory authority. It can be only done by the appellate authority or a regular process of reviewing by the competent authority would have been there. The clause of medical examination in the advertisement runs as follows. There was a clause, my lord, that is why they are referring to. Candidates who will be selected for appointment will be required to appear before a medical board for certificates of their fitness for government service in the form prescribed for the purpose. So normally known to everybody that a fitness certificate is required after they are selected and they are offered the appointment. The examination was thus for ascertaining of fitness and not for quantification of percentage of disability. Such quantification of disability has already been made by the competent authority. The respondents have not challenged the said certificate dated 19th February 2017, and that as such, the remark that the petitioner was not eligible to avail handicap quota is not acceptable. Definite finding of the court. Honorable Calcutta High Court. It is not a case that the petitioner is unfit to perform normal duties on account of debility resulting from illness or other factors. The document dated 27 December 2019 does not say that the petitioner is unsuitable or is having ill health. A scrutiny of the said document would reveal that the petitioner was stated to be unfit on account of the percentage of disability, that is 7%, not eligible to avail handicap quota after recording under column 6, hearing almost normal. The remarks are thus pertaining to the petitioner's disability percentage, when such percentage has already been determined earlier by the competent authority. So is the case here. Already determined, they cannot just give an opinion and that opinion will have no bearing at all. For the reasons discussed above, the order impugned in the writ petition is set aside and the respondents are directed to appoint the petitioner to the post in which he had been recommended by the PSC, be the memo so and so, within a period of 4 weeks from the date of communication of the order. With the above observations and directions, this petition disposed of. Urgent photocopy should be placed before the authorities. Therefore, facts are almost similar with this case. That's why I have placed this before this honorable court. Here also, the opinion already given, if the notification, advertisement. What was it? Place করেছিল। In our case also, as I placed it earlier, I have annexed that recruitment notice, advertisement A 237, page 237 in volume 1. Lordship may kindly look into it. There, Lordship has taken note of. It says, in conformity with the rights of persons with disabilities Act 16 and in compliance. Condition 16, Lordship has taken note of earlier. I referred to, I just want to reiterate it. So and so, dated 2/11/18, it is specified that the reservation for persons with disabilities will be as follows. That is 1% each for these categories, and then for others, 1%. There is nothing like. So when our eligibility was decided on the basis of the certificate that was issued by the competent authority, and that was acted upon, and was ultimately our selection was recommended. We were recommended for appointment. At that stage, the authority changed the course, suddenly took a turn and denied the opportunity to us on an extraneous and irrelevant consideration, defying the all norms and laws. Therefore, Lord, my responsible submission is, posts are there, might be lying vacant because those who are not filled up. There are a lot many PWD candidates. Out of them, most of them were rejected. And they were asked, in interim, they were asked not to fill up the post without the leave of this court. Therefore, what's that? Ordered it to labor. So, the authority should be directed to consider and appoint us. The consequence, as I am open to this. Merely raising an allegation of fraud is not enough. That they got some allegation in some other case, therefore they had to go for it. That is not enough. That has to be very specific, subjective to the individual and then inquired into and then take the call. And more particularly when you have just appointed, 30 of them have been already appointed. I am told subsequently some of others have been also appointed. And more particularly here in this particular, against this particular advertisement in this DEE, they have taken this course, but in all other departments, I am told that there was no such scrutiny gone. The certificate is the only basis. Certificate which was granted and produced, that is the only basis. And in fact, that is the basis. On that basis, you have acted upon, taken the whole process into the close, found us eligible, and suddenly you turn around and say, no, how can this be permission? It is not permission. So, my response submission is, had there been some specific definite allegation of fraud committed by some individuals, or that in large scale in certain districts by certain officers, yes, there would have been an occasion to inquire into, look into. Till then, the matter could have been kept at bay. Yes. Nothing of that sort has happened here. Nothing. Rather, your allegation of fraud falls through because you have yourself again given this advantage to the others in a subsequent round of recruitment. Therefore, in my response submission, this cannot be allowed to go ahead, and direction should be, definite direction should be issued that they have a duty to act upon, and the mandamus should be issued to them so that the petitioners are appointed, those who are not yet appointed. That is my response submission. I'm, as I submitted earlier, this honorable court, by issuing such a direction, will never stop them, the government, from proceeding. If at any time, anything, any material is detected against anybody, to proceed, then they can take the call. But not in this way. Therefore, well, I think I have come to the close. One thing more, it might be argued, I have been indicating, because this is their point only to say that there were some overall fraud practiced. Only ground, that is the only ground. That is why we had to go for. But they have not placed any finding on that before this court. Any finding on that? Yes, fraud vitiates everything at the initial stage itself. But this is a very serious allegation having serious consequence on the person, on the future, on the career, on the status of the person concerned. Therefore, the authority cannot lightly argue this point, and it cannot bear any water to deny the fundamental right to deny the rights flowing from Article 14 and 16 of the Constitution to the petition. Supreme Court said, yes, but you will have to definitely find out, take action, giving notice to everybody. Even on the ground of fraud, if you want to proceed against anybody, you will have to have taken to a course where you will must fulfill the requirement of principles of natural justice. Otherwise, no. So, here, leaving aside the other aspects, the government has not been able to bring in on record anything, even except that mere bogus allegation that there is some fraud and all, which again they have contradicted themselves by giving them opportunity in other bills. By as per submission, I may not have to trouble your lordship taking into all that. Here is a case where this honorable court will be pleased to be happy and satisfied to issue a mandamus today. As I am harping upon, they may also say again that the decision we have taken in that meeting presided by the Chief Minister, Honorable Chief Minister, and my notes we have placed. So that's all. That authorizes everybody and we can go ahead with that on. Therefore, it supersedes everything. In my full submission, that argument will also not fit in here. It cannot replace the legal provisions. It cannot make any amendment to the legal provisions, and more particularly, as I have already submitted, my lord, this was a minutes only. This never percolated into the society in the form of a order under Article 166 of the Constitution. Nothing. And so, Precedent Singh's case will heavily come against them if they argue it at all. I am just indicating. Precedent Singh's case will heavily come against that constitutional decision. That some comment, some minutes written in the file by the higher authorities or the highest authorities, even the Can Commissioner's case, Lordship may remember, the Chief Minister gave a note in the file and they wanted, it was sought to be taken advantage of that. Court said, no, sorry, that is only a noting in the file. No specific order to enforce it has ever been passed. Therefore, you are not entitled to. The other side wanted to take advantage. The employee wanted to take advantage there. So this is the loss of that copy I have given to your lordship. Lordship may see at paragraph. Just note the small certain few lines from 3-4, paragraph 3-4, first few lines, and paragraph 9. Paragraph 9. The question therefore is whether he did in fact make such an order. Merely writing something on the file does not amount to an order. Before something amounts to an order of the state government, two things are necessary. The order has to be expressed in the name of the governor as required by clause 1 of Article 166, and then it has to be communicated. As already indicated, no formal order modifying the decision of the Revenue Secretary was ever made. Here, this Revenue Secretary passed an order and the Revenue Minister sat over it and passed some noting in the file. He passed certain his own views in the noting. And that was sought to be taken help of by the party. Then court said, no, you cannot. Therefore, tonight, and lastly, my lord, I will be relying on the decision of the Constitution Bench of the Apex Court. There's Prakash Pathak and others. Here, the issue was referred to the Constitution Bench as to whether the rules of the games can be changed at any time That's it. My lord, how the reference arose, let me see at the para 1. A 3-judge bench of this court, while accepting the salutary principle that once the recruitment process commences, the state or its instrumentality cannot tinker with the rules of the game. Quote unquote. Insofar as the prescription of eligibility criteria is concerned, wondered whether that would apply also to the procedure for selection. In that context, doubting the correctness of the coordinate bench decision in K. Manjusri for not having noticed an earlier decision in Subhash Chandra Marwaha, Vide order dated 20th March 2013, it was directed that the matter be placed before the Chief Justice for constituting a large events for an authoritative pronouncement on the subject. Now, taking your lordship to be just your observation. Kindly come to paragraph 37. Here it says the procedure E, note E, my lord, capital E, procedure prescribed in the extant rule not to be violated. In Sivananda's city, the issue before the Constitution bench was whether for selection minimum marks would be prescribed contrary to the extant rules and the advertisement. Answering in the negative, the Constitution bench, speaking through one of us, Dr. D.Y. Chandrasud, CJ, held, the Administrative Committee of the High Court decided to impose a cutoff for the Viva Voce examination, actuated by the bona fide reason for ensuring that candidates with requisite personality assume official judicial office. However, laudable that approach of the Administrative Committee may have been, such a change would be required to be brought in by a substantive amendment to the rules, which came in much later as noticed above. This is not a case where the rules of the scheme of the High Court were silent, where the statutory rules are silent. They can be supplemented in a manner consistent with the object and spirit of the rules by an administrative order. In the present case, the statutory rules expressly provided that the select list should be drawn up on the basis of the aggregate marks obtained in the written examination and the viva voce. Rules. Yeah. On the basis of the aggregate marks obtained in the written examination and the viva voce. This was further elaborated in the scheme of examination, which prescribed that there would be no cut-off marks for the viva voce. This position is also reflected in the notification of the High Court, dated 30th 7th. In this backdrop, we have come to the conclusion that the decision of the High Court suffered from its being ultra-virus, the 1961 rules. Therefore, it was interfered. They referred to this Sivananda city. They have referred to appointment may be denied even after placement in the select list. Now, Malad, let us read F. Appointment F. Malad, para 40. Appointment may be denied even after placement in select list. In section C above, we have already noticed the Constitution bench decision of this court in Sankarasam Das Supra, where it was held unless the relevant recruitment rules so indicate, the state is under no legal duty to fill up all or any of the vacancies. However, it does not mean that the state has the license of acting in an arbitrary manner. The decisions not to fill up the vacancies has to be taken bona fide for appropriate reasons. And if the vacancies or any of them are filled up, the state is bound to respect the comparative merit of the candidates and reflected at the recruitment test, and no discrimination can be permitted. I just pointed out because they may say, we may appoint or may not, but this is not an arbitrary. More particularly, they advertise the post and equal number of candidates were only selected. So it is in the public interest that everyone should be appointed. And more particularly, here is a class, a group of candidates who belong to a special class, who needs special accommodation, who needs a special consideration under the special law. So conclusions 42. We therefore answer the reference in the following terms. Recruitment process commenced from the issuance of the advertisement calling for applications and ends with filling up of the vacancies. The whole process includes filling up the vacancies. This is the entire process. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement which is not contrary to the extant rules so permit. Even if such change is permissible under the extant rule or the advertisement, the change would have to be met the requirement of Article 14 of the Constitution and justify the test of non-arbitrariness. So I think this clarifies. We need not have to go to the other. As I have already said, there is nothing in the recruitment rules to suggest contrary. Therefore, the whole process has been taken into a logical end, and that logical and after that is arrived at, and we come at the end of the whole process in the recommended list, we are entitled to the benefit of it, and they cannot deny us. That's my responsible submission. What my learned friends say, Mother, I may have to reply.
Is the health department a party?
Health is not a party.
Health is a party.
Huh? Medical board is a party.
Health is also a party.
Health is not, but medical board has.
Respondent.
No, Commissioner Health is there, man. Two.
You have not filed your affidavit earlier?
Here we have, here we were asked to conduct the examination and this place.
That is the whole issue.
No.
When you conducted the examination, on what basis did you disqualify the people?
No, Lordship, we were asked by the department to conduct the, so here directly we do not have the say because the recruitment and the entire process was done by the education department. We were merely asked to get the report on the petitioners, whether they are genuine candidates. That is all, Lordship. Here, regarding the legal issue, we were not asked, we were not we had no role in this.
Because earlier there was an order passed by this court.
Lordship.
If I'm not wrong, yesterday or day before yesterday, we were going through a particular order.
Lordship.
Nine 124.
9?
124.
Over 29.
could not place it.
9/1/24.
Lordship.
Of course, 9/1/24 is directed to the Standing Council Elementary Education.
Because medical report is to be submitted to the director.
Yes,
It is at the instance of the director it was done, therefore.
yes, Lordship. We had, the reports are with them, Lordship. If the reports need to be furnished, we can do it because
That has been placed. That bunch of them,
Yes,
the signature of the principal and the.
this, the subject matter of this litigation, my lord, is not an isolated one. Last, my lord, from around 2022 onwards, the subjecting the persons with disabilities came up with particular certificates as required under the on every recruitment process, the selected candidates have been referred to a medical board. It has happened not only in the education department, it has happened in the health department itself, it has happened in all other departments. So there are some of the departments which require a mandatory medical test for fitness or otherwise. And there are some departments where we need to verify the actual status of the petitioners, though something is reflected in the certificate. Number why this, if I may say so, a review medical board? Why this is done? The Act, Person with Disabilities Act itself recognizes at section 91 or 92 that there may be a fraud in obtaining the certificate. Yes, madam, the Act of the PWD Act, madam, has section 99. I just take up. 16 Act. 2016 Act. 19. There are 91 to be also. 91. Where are 90? Punishment. Not all. This punishment for fraudulent.
Majumdar,
My lord.
I've seen the text 91.
My lord.
This is for punishment.
Yes.
So the fraudulently.
The concept of a fraudulent certificate.
No, one thing. In the past, or from 2022 onwards, we may have been doing it. But this issue was not raised at any point of time. Now, by only in this particular case, now they've come up with an issue. Now, whether you can discard the disability certificate issued by a competent authority provided under the institute by a medical board constituted by you.
That is, my lord, that is
Now,
settled.
that is the issue that court has to
That is
answer.
settled by, in my humble submission, that is settled by two judgments. One from the Orissa High Court and one from the Supreme Court.
Okay.
Saying that once it is brought to the notice of the court, had they come at a time when we were going for a review, perhaps a stoppage could have been there. Once they participate and there is a medical report, two specialists have opined two different ways. Now, in the eye of this second medical board, which says that no, you do not have that much of a disability, that cannot be ignored, overlooked by this honorable.
No, that's why.
So that judgment is there.
What the learned senior counsel.
That I will come to.
The whole, now the court is placed in a situation.
My lord.
Where this court will have to take a decision whether the certificate issued by a statutory authority can be discarded on the opinion made by a medical board constituted by you.
In one of the
Particularly, if I'm not mistaken, section 52 of the Act.
Yes.
Section of the
50
Act provides for the revocation of what was it for the
Revocation of registration. Revocation of registration.
The revocation of the registration.
So because in that notice, which was issued by the director of Validity, there is a particular in the second paragraph. It says because of some news item, because of some allegations from certain quarters, this medical board had to be considered. This is what we are made to understand. Anyway, you can proceed in the manner you want, but this is what this court is just indicating you that you can highlight on this.
51, if Lordship will see section 52, 50, 51 and 52. Prior to that, my lord, this registration has to apply to section, it starts at 50. Let us see 50, my lord. 50 is, save as otherwise provided under this act, no person shall establish or maintain any institution except in accordance with a certificate of registration. This is that registration which is being referred to, my lord. This is not the registration of the person with disability. I'm sorry. This registration is of an institution.
Okay, registration of.
So this 52 and 52 has got nothing to do with the person with disability. It has got to do with an institution.
92 will apply.
92 comes in. When 92 comes in, if a man is fraudulent, punishment has to be there. Now, whether fraudulent or not, one comes with a certificate before us. What has fallen? What has come from the other side is, if I am a fraud, you punish me, you do this, do that. Is it necessary that we take in a person and then find out a fraud? That cannot be the argument. The argument will be stop fraud at the initiation. You have a certificate. You tell us that you have got this and that. We say go and face a board. Now this board, my lord, does not come in thin air. There is a notification by the government of Assam which says that in every case there has to be a medical and we have the right to review it. 21st of May 2022 is the notification. Now, Lordship of the OM, if Lordship has the second page, the certificate of disability. Sorry?
Second page.
All of 4 to 9. Second page, 5. Lordship will find. Certificate of disability. A person who wants to avail the benefits of reservation will have to submit a certificate of disability issued by the competent authority. Such certificate, in the event of selection of such person or for any post, will be subject to such verification or re-verification as will be decided by the competent authority. Now, this has been considered by this honorable court in the case of Bhoinda Devi. Bhoinda Das. Learned single judge had dismissed those petitions. The further fate, I do not know, my lord. I was told that there was a writ appeal, something happened, but not successful in the writ appeal is what I know with surety. Perhaps it was withdrawn with a liberty to review or something like that, but the writ appeal does not exist of today. As of today, the order of the learned single judge holds the fee. Taking into consideration this very OM. Judgment Bhoinda Das is in Yes, Bhoinda Das. That is WPC 2995.
Can you conclude today, Mr.
My lord, I'll make it as short as possible for my submissions. If my lord, I will not read the whole thing. Perhaps we can have some time where learned senior.
No, if you can conclude today, then we'll hear you. Otherwise, we can pick another day. That's all.
Lordship's convenience, because I will be referring to about 5 or 6 judgments.
Okay.
That is it. And my
and then Talia.
Either which is not, even if it is taken on, because I have given the detail of Bhoinda Das today. Perhaps learned senior would like to go. What is the one that is with Lordship?
OM?
The judgment, my lord, the 299 of 2995 of 2024 Lordship fine. Here, most of the arguments which have been done have been addressed by the court bench on this honorable
Now-
my lord. Now, my lord, will find that paragraph 15.
Let me also go to, we'll fix a date.
And I'll give one or two more judgments, one from the Odisha High Court and one from the Supreme Court.
But Mr. K. Mahandal. K. Mahandal. Assisted by MS and also our multiple standing council, elementary. Elementary department and Mr. H. and standing council, health department. Thirteen part. We'll have it on Tuesday. Is it convenient to you?
Tuesday.
Senior council.
Yes. But Tuesday and Wednesday, I may be out of station in Meghalaya.
Then Thursday.
I think we finished, Mala.
Yeah, we'll try.
As early as possible.
Monday is fine with me otherwise. 19 and 20.
More on you Monday for half an hour, 45 minutes.
I'll take not more than 45 minutes. That I can ensure. I'll read 5 judgments. We stand there.
Monday, I'm very doubtful whether my bench will be there.
Let it be on Thursday. Let it be on Thursday.
Okay, 21st. Begum, can you give a typed copy of this list? The next.
Nó có mua khách chứ. Nó có đang để rồi, không phải có quay đó nào. Ví dụ thế đó.
11 and 12 of daily list.
Oblige, my lord.
Make pleasure losses.
Was it Naya?
Yeah, Naya would like to file affidavit, my lord. I don't know why, because earlier they have filed, my lord, on basis of affidavit. There are several orders, my lord, passed by this honorable court. Yes.
That was when I was just writing
Yes.
in the first part. He saying that some new developments have taken place and he wants to place it on record.
No, my lord. Last occasion, my lord, they have filed one letter by this secretary. Lordship, kindly peruse the last order, my lord. They would like to make a committee, my lord, to whether we are eligible or not. Whereas they have long back filed that we are eligible and they are going to regularize our services, my lord. And on 17/7, my lord, 2024, they have stated that last stage of this last stage is going on, my lord, to regularize the service of the petitioner. Now he wants to file because they have twisted the matter, my lord. They would not like to appoint, my lord, regularize, my lord. Yes, my lord.
Dated 28. 1 minute, Naya.
Yes.
39/2020.
Yes, 39/20.
Last one says, the PTC may file an additional affidavit.
Yes, regarding controversial, yes.
Communication as well as the requirement for continuous custody. So let him file the affidavit and then.
On this point, I may be allowed to protect my lord. So status quo as on today, because nowadays they are going to every time they are submitting some letter from this.
Going to happen which would
No, nothing is there, Lordship. They are simply praying for regularization.
Here is okay, then Nayak, what I'll suggest as the petitioners are expressing urgency.
Yes.
You want to file your additional
Yes,
affidavit?
Lordship.
I'm not stopping you from filing that.
Lordship.
But I'll give you a short time.
Lordship.
File your affidavit at that time and the next day will finish.
Lordship.
That is 39/2024. Today is, my lord.
Lordship, this is an notification of 28 October 2024. And that order was of 39. So
Last occasion also, lordship, they have stated that.
but this was never produced before the court, Lordship. This is 28 October 2024.
Okay, her MSK did it. Mr. P. Nayak.
Every day he comes and, my lord, submit some letter, my lord. This is not the way, my lord. And I do not know anything, my lord. Just he submitted before your lordship, and lordship passed an order, and he never give it to me also. Before that, he should give me to me, so that I should know.
I give it to you. Why should I give it to you?
Why not? Why not? This is public document.
Public document, go file RTI application.
And the
ক'ব নোৱাৰো ভাই, কিয় কাজিয়া কৰে মানে ৰখিলে যে এইখিনি সময়।
When do you want, Nayak?
After 2 weeks.
29?
Oh, 29, I will be not available, my lord. 29, I'll go to Delhi, my lord. Before that, 25th, my lord.
That will
Because
not-
I have a second checkup
25 will be too early.
for my health.
When are you coming back?
I'll be back on 10 December. No, before that, my lord. Otherwise, I don't know what will happen, my lord, after second checkup. So, my lord, 25th.
No, 25th will be difficult. When are you leaving for Delhi?
28th.
In the first week of December, then second week, first week, second week.
You will not be there.
Yes, my lord.
Then later come back.
Maybe, no. Maybe I maybe stay there if something happened, my lord. God knows.
Nothing will happen. You are looking healthy. It's just a normal checkup. We'll have it on 11.
I become old, that's why, my lord. When, my lord?
11.
Highly obliged.
20.
Yes, Your Lordship. I was to produce the NOC, Your Lordship. So already the yes, government has already relaxed it, and based on that, the revised authority has already been prepared. Just for signing purpose, it is there. So they will do it by today, and we'll
We'll take it up next week.
yes.
But Mr. HD,
Been done.
Mr. B. Devril and the governor has produced a communication dated 14/11.
Yes.
2024, written by the Undersecretary to the Government of Assam, ART-DPG Department, and addressed to the Director of Pension, conveying no objection towards releasing of the error family pension to the petitioner, is it?
Yes, Your Lordship. To the petitioner.
To the petitioner.
Present physically handicapped.
By the pension sanctioning authority as per SOP 158 small p of Treasury rules and subsidiary rules, read with rule 226 and 227 of the Assam Service. He therefore prays for a week's time to enable him to receive total updated. When do you want?
Lordship, if your lordship permits 2 weeks, before that I'll
What it is, he press 2 weeks.
payment একেবারে হয়ে যায়।
Praise the Lord. This on 2nd of December.
Yes. Oblige, your lordship.
Oblige, my lord. 21.
What is it?
Lord, petitioner's husband was died on 10/12/2023, my lord. Earlier getting pension, my lord. After death of the petitioner's husband, my lord, pension was not.
This is coming up for the second time.
Yes.
Appeal. Yes, you Shama
Earlier.
secretary. Government PWD. Where's the secretary? Report?
Provisional pondo yes. Lordship, since the matter relates to provisional pension, concerned nodal department will do it. We deals with regular bills.
Where's the, you are praying for?
Accountant General.
Okay.
Lordship, we are not dealing with the provincialized soul, Lordship. We have an instruction, Lordship.
No, that's fine. You keep it with you. At the relevant point of time, we'll see that you are discharged. Fukan, are you appearing secondary? No. You are elementary.
I'm elementary.
Secondary,
SMD.
where is he? Yes, police.
That's
I can.
Instructed.
Here, Your Lordship, this matter is pertaining, need be doing a NJ Khatunier, Your Lordship. On behalf of NJ Khatunier, I pray for some time, Your Lordship. May be granted. 1 week time may be granted to us, Your Lordship.
Have you received instruction?
No, not yet, Your Lordship.
By 1 week, you'll receive instruction.
Your Lordship, I'll try to obtain it, Your Lordship. 2 weeks time may be granted, Your Lordship.
M. Ahmed. Editor.
Okay.
On request made on behalf of NG Company,
Date may be fixed, otherwise. Normally, no.
Second time it's coming up.
Yes. Family pension, 2 wives are not.
You make a mention if
Obliged.
22.
MS, you put them. A? Sharma Leonard Council appears on behalf of Mr. P. Chakraborty, the Standing Council. Accountant.
May I please, Your Lordship? elementary department, my learned friend always disputing this. This is not covered as per judgment of the court. First, allow him to submit his case. This is not covered. Then I will submit. Disputing is not covered by the judgment of the court. First, allow him, Lordship.
My lord, some time may be given, my lord. I'll get my instructions, my lord. We are still awaiting our
times. Fourth.
So many times.
Obtained.
Mrs. Sharma was there, my lord. I have written. We have written to the department, my lord.
Okay, her deputy
Next week, my lord.
on request made by Mr.
If on behalf of Mr. P. N. Sharma.
On request made on behalf of Mr. P. N. Sharma, something from the elementary education department.
For final disposal. Annex for us.
When?
Any day.
Page 48. Lordship on 19.
19. Twenty-six is a good case.
Lordship.
Let's get it.
My lord.
This one about that one.
30 to 33 of implementation.
আমার মানছে নি মেট কি জল আছে I have not seen the other assignment.
Where's
Authentic.
Where's
Bar Council of
No.
Elementary Education and Bar Council.
Elementary to सकते
London Council Guwahati University took adjournment last time. Where's the Guwahati University? Can you go out?
Anyway, huh? Anyway, my lord, to start with, my lord, your lordship once heard this. So it deals with the B.Ed and B.P.Ed education that is controlled by, my lord, NCET Act 1993. So this is central government parliament has enacted that act to streamline the teaching of the teachers. And my lord, here we have first we have to apply for affiliation to the university concerned, and then they send some inspection team, and that will be reported to the NCET local body here, and then they will consider our affiliation. Now, my lord, we have applied for recognition to the university on 23/3/22, and that has been received by university on 28/3/2022. And there was a notification.
You are arguing on which bit? The first page?
My lord?
Are you on 821? WBC?
Yeah.
You are arguing
821. Yeah. So we have applied for that, but in the meantime, one notification has come from the government through which at page 31, my lord, that was the internal notification. They say that you need to, your lordship will read it. It is notified for information of all concerned that from now onwards, Guwahati University will accord permission to open new college subjects after obtaining no objection certificate from the government
by respective institutions. Therefore, all concerned who have already applied for the same but are pending for decision are hereby requested to submit government no objection certificate in the office of the Director, College Development Council. Also, the college concerned bodies are who are interested to open new college stream subjects are to submit government no objection certificate along with the necessary application, without which the matter cannot be proceeded. This is issued as per the EC resolution number so and so dated 29/3/2029. My lord, your lordship will now come.
Initially, you were
We applied for recognition of the university, and that was pending. In the meantime, that notification has come, and then they say that
your first application was 23/3/2022.
yes, ma'am.
So the annexure 2.
Ma'am.
In the meantime, that notification
They will
came.
come, and so they said that you require to have the now. You will also kindly go to page 8, era 2, to know the background, man. That the petitioner begged to state that the Guwahati University in this regard proceeded with the application and sent committee of inspectors to inspect the institution as per the criteria specified under the processing of application required for NCET. But surprisingly, that in the meantime, the university issued an impugn notification dated 24/5/22. That is, the application was made by the petitioner stating that the Executive Council resolution was passed on 29/3/22 bearing number so and so, that any prospective institution requiring first to seek no objection certificate from the government in order to obtain NOC from the Guwahati University. This impugn order was in violation of the guidelines stipulated in the NCTE regulation 2014 and the judgment passed by Honorable Supreme Court. The state of Maharashtra Bharat Dhyaneswar so and so reported in so and so, where it was held that no objection certificate from the state government is absolutely not required by the university to provide consent for affiliation. I will take your lordship to 2 paragraphs of that particular judgment. Then your lordship will go to page 11. Page 11, para 5. Only to show that we have paid the required fees, etc., to the university. That the petitioner begged to state that Hamak College of Higher Education, Nagaon, Assam, is funded by Hamak so and so. In the year 22, it is decided to undertake affiliation to government Guwahati University for undertaking B.Ed, BSc B.Ed, BPEd courses as per the guidelines of the National Council for Teachers Education. That in this regard, by the reference number so and so, dated 18/2/2022, the petitioner paid rupees 4,84,000 to the university in order to obtain the no objection certificate for affiliation of BA, B.Ed and BSc B.Ed courses which were duly recognized by Guwahati University. Pursuant to this, State Council of Education, Research and Training, SCERT, Assam, submitted an inspection report for the B.Ed and BPEd courses to the Elementary Education Department, Government of Assam, for recommendation to the Regional Committee of the National Council for Teachers Education. So they have started processing our, my lord, application. Then is 15 para 10, my lord. That the petitioner begs to state that National Council for Teachers Education is an authority established by the parliamentary statute to achieve a planned and coordinated development of the teacher education system throughout the country and states uniformity, the regulation and proper maintenance of norms and standards in the teaching education system, including school teachers and for matters connected to it, therewith. Though the National Council for Teacher Education 1993, namely NCT Act, the Parliament of India established a authority which under Chapter 5 authorize the body to recognize teacher educations. Under Section 14 of Chapter 4, every institution offering or intending to offer a course of training in teaching education on an after appointed date would make an application to the regional committee concerned in form and manner determined the regulation of the day. The NCT is the sole authority to grant recognition without interference of the state government or any authority. On receipt of the request, the said regional committee shall grant affiliation or cancel affiliation as per the rules mentioned therein. Thus, the Parliament of India, in the exercise of its power under entry 66 of list 1 of Schedule 7 of the Constitution of India, empowered National Council of Teachers Education as the body for issue of teacher training in India. That petitioner begs to state that NCT notification dated 18th November 14, namely National Council Teachers Education Recognition Norms and Practice Regulation 2014 under Section 4, Clause D, a self-financed educational institution established and opened no profit society and trust registered under the appropriate law or a company concerned under the Company Act is eligible to be considered for application under this act. My lord, these are the things, my lord, I want to, before that,
What
my
you're
lord.
trying is that the NCT is the only authority.
My lord.
that can turn on the-
My lord.
No objection, demand a certificate which is demanded by the state government. They don't have the authority. to
My
do
lord. That is without any jurisdiction or any competence. I have made these three, my lord. Yes, sir. 26 October. Now, first, to know the minor background of this case, on the factual part, I will want to show to your lordship. This is the state of Maharashtra versus son dinosaur something. First, please, my lord. The present appeal are directed against the judgment and order passed by the High Court of Judicature at Bombay on September 28, 2005 in writ petition number so and so of 2005 and cognate matters. Writ petition number 47469 and so was filed by the Sant Dinosaur for an appropriate writ, direction, or order, quashing and setting aside the order dated December 28, 2004, passed by the state of Maharashtra, by which the petitioner was informed that the state of Maharashtra had taken a policy decision not to grant no objection certificate, NOC in short, to any institution for starting new B.Ed college for the academic year 2005-2006. It was also decided to communicate this said policy decision to the Maharashtra University, stating that if necessary, it will arise in the next year. Application for this institution would be considered at that time. A decision was also taken to bring it to the notice of the National Council for Teachers Education, Bhopal, that in the state of Maharashtra, there was no need for new B.Ed trained manpower, and hence NCTE should not directly consider any application for grant of permission to start B.Ed colleges. In spite of the aforesaid policy decision of the state of Maharashtra, the NCET granted permission to the petitioner institute. The state hence challenged the said action by filing writ petition number so-and-so, contending that the decision of the NCET ignoring the policy decision of the state government dated so-and-so was not in consonance with the law and is liable to be set aside. Then your lordship will go to page, my lord, 5 of 34. 5 of 34.
Yes.
5 of 34. The High Court held that in the light of the relevant provisions of the Act, as interpreted by this court in various decisions, the appropriate authority to take decision regarding opening a new college was NCET, and neither the state government nor the university can act contrary to the decision of NCET. According to the High Court, under the Act, the only authority which could take a decision regarding the opening of new B.Ed college or increase in the intake capacity of the NCET, either by the state intake capacity was NCET, and such decision cannot be ignored either by the state authority or by the universities. So far, as the function of the state government was concerned, the High Court observed that it was in the nature of supply of necessary data and materials so as to enable NCET to undertake the process of coming to an appropriate decision, but the state had no power to decide decide that it had taken a policy decision not to grant permission to open up a new B.Ed college for a particular period. Such a decision was not according with the provisions of the Act, nor the consonance with the law laid down by this court. Regarding role of the university, the High Court held that it was incumbent on the university to take a appropriate decision and consequential action on the basis of the decision of NCET and the provisions of the University Act requiring the university to implement such decision. It was therefore not open to the university to take any action overlooking the decision of the NCET and relying on the decision of the state government. So your lordship has found that NCET is all powerful, and this has been also the Supreme Court has also in your lordship will go to page 26 of 34. The second paragraph, my lord, from above. From the above decision, in our judgment, the law appears to be very well settled so far as the coordination and determination of standards in the institution for higher education or research, scientific and technical institutions, the concern are concerned, the subject is exclusively covered by entry 66 of list 1 of the schedule 7 of the Constitution, and state has no power to encroach upon the legislative power of the Parliament. It is only when the subject is covered by NT 25, that is my lord, concurrent list 3 of the schedule 5 to the Constitution, that there is a concurrent power of Parliament as well as the state legislature, and appropriate act can be by the state legislature subject to the limitations and restrictions under the Constitution. I will show your lordship the NCT Act. There it has specifically said that the state government can make only in part 3 and part 4. And part 1 and part 2 cannot be touched by state government or make any regulation on that. In the instant case, admittedly, the Parliament has enacted 1993 Act, which is in force. The preamble of the Act provides for the establishment of National Council for Research Education with a view to achieving planned and coordinated development of the research education system throughout the country. The regulation and protect maintenance of norms and standards in the teaching education system and for the matters connected therewith, with a view to achieve that the object National Council of the Teachers Education has been established, and at possibly at the 4 places by the central government. It is thus clear that the field is fully and completely occupied by an act of Parliament and covered by entry 66 of list 1 of schedule 7. It is therefore not open to the state legislature to encroach upon the said field. Parliament alone could have exercised the power of making appropriate law. In these circumstances, it is not open for the state government to refuse permission relying on a state act or on a policy consideration. Then your lordship will go to page 27 of 34. 1, 2, 3, 4 paragraph below, my lord. In view of the fact, however, according to us, the final authority lies in the NCET, and we are supporting it, taking the view by various decisions of this court. NCET cannot be deprived of its authority or power in taking an appropriate decision under the Act, irrespective of the absence of no objection certificate by the state government or union territory. Absence of non-production of NOC by the institution, therefore, was immaterial and irrelevant for the power of NCT to NCT is concerned. So, my lord, it is clear from this Supreme Court judgment that NCT is the only power. But then that the notification, impugn notification, which is contrary to the finding of this, should be struck off, and it should not be applied in the present case. And our affiliation or recognition by the university should be considered on the basis of the instruction made by the NCET. और की बच्चे लिखिए another case, my lord, in this respect, in the same line. Only I will. This is your lordship will directly go to para 12. Para 12 of this judgment. Even a policy decision taken by state in exercise of its jurisdiction under Article 162 of the Constitution of India would be subservient to the recruitment rules framed by the state, either in terms of the legislative act or a proviso appended to Article 309 of the Constitution. A purported policy decision issued by way of executive instruction cannot override the statutory rules or less the constitutional provisions. So here, my lord, this is an executive order based on the instruction of the state executive that has been followed by the, that cannot be, that will not be illegal, my lord. So when, my lord, basically, when the NCT is the proper authority, they will, university is to act not on the basis of the instruction given by government, but we will have to act and take an independent decision on the application filed by us, whether they will give us recognition or not. That is my submission report. So that notification that has been issued, annexer 2 to the petition is liable to be quashed as contrary to the provisions of the Act and the rules. Then, my lord, another thing, my lord, which my learned friend has filed in the affidavit. To answer that, my lord, your lordship, I would kindly go to page 44. Page 44, huh? Affidavit in opposition. And reply. And here is the million. Para 4, your lordship has fine. Page 44.
Yes.
Para 4, page 44. That with regards to the paragraph 3 of the deponent wholly denies the assertion and beg to state that respondent number 4 have time and again brought up the allegation stating that the other petitions filed by petitioners' college are in the same subject matter, which is wholly incorrect and misleading, as the subject matter of WPC 794/2030 relates to BSc B.Ed, 4 years courses, and the BA B.Ed 4-year course. These are 4-year courses, these are new course that has been completed. So a new different WPC. And WPC number 3782/2022 relates to the courses of LLB and LLB 5-year course. So this petitioner trust that they have applied for LLB and LLB 5-year course. So it is a different course and their rules, regulations, everything different. Well, without taking recognition and affiliation from the university, we cannot run. So we have to file this separate. Then, my lord, WPC number 4212 to 4024 relates to the matter of deleting the name of the affiliated colleges from the list of affiliated colleges, Guwahati University, without notice, which shows that there are clearly different subject matters and not same subject. This matter was also taken up by the Honorable Court, was pleased to segregate petitions as above. So that order 28/824, this has said that these are different subject matters. So this will be heard separately. So that order is also there, madam. Your Lordship, then it is also pertinent to mention herein that the two communications of Guwahati University that are mentioned in the affidavit in opposition, namely so-and-so dated 18/8/22 and memo number so-and-so 18/8/22, not relate to B.Ed 2-year and BPEd 2-year courses, which are subject matter of the other petitions. Then, my lord, 45, the Hamak Rural College Education and the Hamak College Higher Education for running BSc, running B.Ed colleges are both situated in the same locality. This was the allegation, my lord, made by the university, which is totally incorrect, misleading, since the above mentioned colleges are not the same locality and are situated at a distance of 3 kilometers from each other. There is no rule prohibiting two or more colleges being established in the same locality also. So this is a very vague type of allegation that has, my lord, cropped in by the university. It is also pertinent to mention here that the respondent herein mentioned the police cases filed against the director of the petitioner's college in regards to pendency criminal cases. It is submitted that the present case deals with civil rights of the petitioner and no stress of imagination one could bring existence of criminal cases which are totally irrelevant for the simple reason that pendency of criminal case against an individual does not curtail the civil right and the constitutional right enjoined by him. Moreover, the Honorable High Court has stayed the proceedings of the criminal cases. This is important, my lord. My learned friend will show the stay orders. The petitioner craves the indulgence of the Honorable Court to produce the orders of the High Court which interferes the criminal cases by granting stay order. The fact of registering a criminal case in Nogao police station by somebody against the director is no way relevant in the present case, and it has no effect in the genuineness of the bona fide of the institution. Moreover, the colleges have already submitted the required documents as sought for. Further, several criminal cases, police cases are pending against the Guwahati University and officials, including former Vice Chancellor who retired on 2025/24, by that neither the UGC nor any other competent authority withdraw the approval of the university or declare the name of the university from the UGC website. Such type of vague allegations made by the university authority is unwarranted. Criminal cases are distinct from civil cases, and the pendency of criminal cases does not negate the individual civil right. As regards paragraph 5 of the deponent, beg to state that B.Ed 2-year courses, BPEd 2-year courses are governed by central government enactment, namely National Council for Teachers Education 1993. The NCT Act nor its rules provide for seeking NOC for the government and university. Therefore, the executive order passed by the Guwahati University 29/3/22 overriding the jurisdiction of NCT, which is not permissible under the law, by asking demanding NOC from the state government first or the university is arbitrary and without jurisdiction as has been held in apex court in the state of Maharashtra, that judgment we have indicated, and some parts of the judgment I have made.
No, so this 821
My lord,
is against that notification only.
my lord. Only notification.
And the other cases, other one is also the same against the notification.
No.
Notification is same, but issue is my case is in case of the law college.
LLB, the law degree.
Law degree, my lord. So there is a different ground too, because our all provisions under the BCI and as well as the UGC affiliation regulation also apply. So that is not followed by university. This is my case.
Okay.
And the other case, your other case?
Yes, another case for it is regarding the affiliation inspection. In case of the B.Ed and two education institution, BA B.Ed and BSc B.Ed, So inspection amount they have received, and one time inspection was done, they have satisfied. After that, they again constituted another inspection committee. That was earlier, that was in member consisting of 2 members. Now they are in 3 members, 2 committee, and again asked to bear the all expenditure.
Then, these are not related.
Not related, but we have done the inspection. They have also done the inspection.
No. These cases are not related with each other.
No, yes, it is all are separate.
It has to be heard separately.
Separately, my lord.
Now, why is it clubbed up together?
Sir, that was earlier segregated on, my lord, in my order. 28.8, but again, my lord, that is been club. I don't know whether whose instance, my lord, this is club. It is not informed to me, my lord. But the lordship was pleased to, my lord, segregate all the cases, my lord. That was subsequently that was done, my lord.
Yeah, Furkan, you can hear this separately.
My lord, 2 cases, my lord. One is the WPC number 82124. The instant writ petition, my lord. And regarding that maintainability aspect, my lord, that WPC number 794/2023. These 2 should be taken together.
No, this is not separate, my lord.
And this regarding law college.
1 minute, 794.
It is regarding the inspection only, my lord.
And 821, same Hame College of Higher Education. So earlier, my lord, in my affidavit, the content of the consent. My lord, that will be decided by this honorable court, my lord, that maintainability question. For that maintainability question, my lord, these 2 cases should be taken together. Otherwise, the maintainability question cannot be, my lord, heard, my lord, by this honorable court.
Which one? In which?
821/24 along with 794/22. These 2 cases. Other 2 cases may be segregated.
So the case we have already argued.
Same college.
College is same. Courses are different. And their situation of the colleges are also different. One is at about 3 kilometers away from there.
On that issue, my lord, I will submit, my lord, and my affidavit is also clear. So that is why, my lord, these 2 cases may be taken together and other 2 cases may be segregated.
My lord, my lord, humble service, one thing, my lord. My learned friend will definitely, my lord, agree with me. My lord, there will be better to heard all the cases separately. My lord, otherwise, my lord, there is a lot of difficulties arise because the all issues are different. Case, my lord, the parties are maybe same. Identities are all different. Issues also different, my lord. So lordship's convenient, my lord, that will be heard separately. So my learned friend, there is no objection because they will not harm anybody, my lord.
I have no objection regarding segregation of the 4 cases, but for one case, the present case item number 30, since the maintainability question is there, for only that limited purpose, this WPC number 794/23 is to be tagged with item 30.
No, 794, what is the issue, raising issue of maintainability there also?
No. This is not maintainability, my lord. This is, my lord, regarding inspection, my lord. I have paid the money. They have not completed inspection. This is my issue, my lord.
My lord, since, my lord, earlier this honorable court's order dated, may I, my lord, take your lordship to my affidavit in opposition.
No. Issue is this. Let us be very clear. Let us not waste time.
Yes, my lord.
If you have to hear it together, we'll hear it together. But then what I'm gathering from now, what I'm gathering as per your submission, is that these issues are different. One pertains to the B.Ed degree 4 years course. One is a 2 years course. One is LLB course. And one is with regard to the inspection.
Inspection, my lord.
Correct.
So LLB course, that writ petition should be segregated. I don't have any objection. That inspection aspect, writ petition should be segregated. But if we come to the maintainability aspect, that res judicata aspect, these two cases should be there, my lord. Otherwise, this honorable court cannot, my lord, go into that question, my lord. The maintainability aspect, if I argue on that maintainability aspect, then these two petitions would be required only for that limited purpose.
All right, my lord, I
Otherwise,
am not arguing, my lord. I am accepting his thing, my lord. But lordship, I prayed that for the lordship convenience, that would have been better to segregate all the cases.
That is why this court will have to write the judgment.
Yes.
And when you're writing the judgment,
Yes, my
it's
lord.
difficult to pass
Yes,
an
my lord.
order.
My lord, synopsis is clear, my lord. From the synopsis, the all cases are different, my lord.
That's what.
My lord,
Exactly.
next, my lord, what is res judicata? I understand res judicata that there should be a judgment by a competent court and the other thing will follow.
Yes.
So there is no judgment till now. So as my learned friend has submitted before lordship, they should be taken separately for the sake of saving time and energy of both of court and department.
Exactly.
so one college may, my lord, if I, my lord, agree with my learned senior friend, then one can, my lord, approach this honorable court with same prayer with multiple number of writ petitions. That cannot be, my lord. That is against the principle of res judicata.
Yeah.
That is why, my lord.
Fukan, once this court takes up an issue, takes up a particular writ petition and disposes of the same, whichever way it goes. After that, the issue of res judicata will come.
Yes, lordship.
After that, the
Very
issue
much
of
correct, my lordship.
before that, you can't raise the issue of res judicata.
Yes, right now is not
My
the
lord,
right time, my lord.
since, my lord, in the other court, interim prayer has been rejected. But again, the same college has come up before this honorable court with another writ petition with the interim prayer.
Okay, let us see in which writ petition interim prayer was rejected.
That WPC 794 of 2023.
Okay. By which order?
7-9?
794 of 2020.
Oh, 2023. Interim order is request.
By which order it was rejected?
My lord, page 21 was the interim prayer. My lord, notice was issued, my lord, date. It is not clear, my lord. But no interim order has been passed, my lord.
In this writ petition, 794.
794. And
This regards to approval and recognition by the Guwahati University with regard to 4 years integrated BA B.Ed program and 4 years integrated BSc B.Ed program.
Yes.
All right.
My lord.
That's all.
My lord, that B.Ed program is there, my lord. And again, the next petition, again that B.Ed program is there. So, my lord,
Which next petition?
this 821 of 24.
That is, Fukan, why can't you understand?
Same course, my lord, B.Ed course.
No, no,
But-
no. Maybe B.Ed course,
But B.A.
but this is 2 years course.
Yes, my lord.
2 years course.
Yes, my lord.
That is, the other one is integrated 4-year
4-year
course.
course.
But the core course is B.Ed, my lord.
Oh,
My lord, I may.
One, my lord, he have to study from 11,
Since,
12.
my lord, since, my lord, it's in the academic sphere, my lord. So, my lord, that technicalities, my lord.
My lord,
B.Ed course, the 2-year B.Ed course, and
LLB BA.
and B.A. B.Ed and B.P.Ed B.Ed. So 2 years, my lord. But the core course is B.Ed. So if one college gets the permission or affiliation of B.Ed course, then he also.
that college will get the affiliation of BA, B.Ed course for 2 years.
Yes, my lord.
The other college will get the affiliation for 4-year course.
My lord, along with
There's a difference.
Different, my lord.
Along with
And
that,
a simple
BA
example, my lord.
B.Ed course is core course, my lord, and B.A. course is added, my lord.
My lord, may I make one submission, my lord? I applied for to the Guwahati University for opening a law LLB degree, BABL, 2 years course. Can I start there teaching BA-LLB 5-year course, which is when in BA LLB one will have to be graduate to get admission, 3 years course, and 5 years course he only be a higher secondary pass. So their curriculum, everything is different, and one college having BA affiliation, LLB affiliation, BA LLB affiliation cannot teach 5-year BA LLB. That is a simple question.
These are totally different issues. I think we'll have to hear it separately.
Yes, my lord. Then, my lord, my that maintainability aspect, my lord. So, my lord,
How that maintainability aspect is there? If you raise the issue of maintainability in either of these writ petitions, we'll hear you.
my lord. Then, my lord, I don't have. Otherwise, I don't have any objection. But only for that maintainability aspect. So, if it is required, my lord, then afterwards, my lord, it may be.
Okay. Heard Mr. A.C. Boragohan, then a senior counsel. Assisted by MS S. Nat. For the petitioners in WBC number 821 of 2024 and 4212 of 2024, as well as Mr. P. Mahanda, learned counsel, for the petitioners in WBC 3782 of 2022 and 794 of 2022. Stop. Also heard Mr. P.G. Fukan, learned standing counsel, Guwahati University. And
A.R. Kashyap on behalf of A. Somar, SC UGC.
and Mr.
A.R. Kashyap.
Kashyap,
On
learned
behalf-
counsel, appearing on behalf of Mr. A. Jamal, learned standing counsel, UGC. And MS M. Borgohan, learned. Learned counsel, appearing on behalf of Mr. P. Mahanda, learned standing counsel, BCI. Stop. Para. After hearing the parties, this court is of the consistent opinion that all these matters should be heard separately. Stop. Accordingly, registry is directed to list all the four writ petitions separately. Separately. When do you want?
When one sorted may be given, my lord, I
Yes,
am because
please.
of the law, my lord, I am
Okay,
suffering.
we'll have it on the same date.
Yes, my lord, no problem.
List all the four writ petitions on its own. On
এটা থেকে করিম।
give a date convenient to all of you.
This month, my lord, is it possible, my lord,
Yes,
this month? So, my lord, on 27, is it possible, my lord? No, my lord, 26, my lord. That will be better, my lord. On 26.
26.
Must be.
Obliged, well. Most obliged. Yes.
The 3 of Delhi order.
20? 23. I saw data was standing.
But on the last occasion, Mr. Khatania took time, saying that he wanted some accommodation. Now, this area salary proposal, was submitted by the DEO. But the DEO is refusing to accept. The district elementary education officer is refusing to.
Where is
pay.
Katani?
Khatania perhaps is today absent and someone took some time on the other in the other case.
Ah, yes,
Yes, sir.
some problems. Okay, then we list it on a short date.
My lord.
Part M data, then the council petitioner on request made on behalf of NJ Catania, then the council applying for the respondents 4 and 5. We'll have it next week.
Next week, my lord. Yes, ma'am.
When?
Lord, next week, my lord.
20?
Pardon, my lord. 20, Lord.
22nd?
22nd, yes, my lord. 22nd.
Yeah, 22nd.
25.
In this case, as far office note dated 7/11, my lord.
Huh?
As per office note, my lord, 7/11, my lord. Neither ID card received for nor answered notice has been received to the respondent number 8. That I am be allowed to take justice service, my lord, to the respondent number 8.
Respondent number 8?
Yes, my lord, headmaster of the.
Okay. Mr.
K. Kolita.
K. Kalita and the counsel for the petitioner. For the review petition. Place for taking first steps for service of notice on the respondent number 8 by Dusty Service to the registry of this court. Stop. Para. Praise allowed. Para. Let such steps be taken and completed within a period of 1 week.
Yes, ma'am.
Thereafter, petitioner shall file an affidavit to that effect. Stop. List after 2 weeks.
Yes, ma'am. My lord, only Dusty, my lord.
Yeah, by Dusty.
26.
In this case, my lord, I am appearing on behalf of respondent. We have filed Ukalat Nama, my lord. 45, 49, 53, 80.
40?
45, 49, 53, 80. I'm appearing on behalf of respondent number 45, 49, 53, and 80.
So you want to file affidavit?
Yes, I would like to file it.
My lord, I am appearing for respondent number 16, 21, 22, 31, 39, 48, 54, 63, and 72.
Petitioner's counsel is not there. None appears for the petitioner.
Who is there?
Mr.
NK Kolita.
NK Kalita, Learned Counsel, enters appearance on behalf of. Have you taken down the numbers? No. On behalf of the respondents, 16, 21, 22, 31, 39, 48, 54, 63, and 72. And MSK Devi, Leonard's counsel, enters appearance on behalf of respondents. 45, 49, 53, and 80. Stop. The Leonard Council appearing on behalf of the private respondents prays for how much time?
2 weeks, my lord.
2 weeks time to file their respective affidavits. Praise a lot. List.
27. Hearing.
Your lordship. Here I am appearing on behalf of senior counsel Mr. P.K. Tiwari. This is the matter pertaining to a seniority, my lord, between the direct recruit and promotee sub-inspectors. Our submissions are complete.
So you have already heard me also. And thing is that there is no specific guideline for this. The DPC.
When was it heard last?
I think 1 month back.
Yes, my lord.
What? 1 month back.
No, my lord.
Busy month. I think before Durga Puja.
Yes, my lord.
we'll have it on a different day.
Lord, may I
It is
pray?
quite
I have
late.
a small prayer, my lord. May I-
Gossip can, I think, we dispose of the matter.
Lord, we'll be filing a written argument, my lord.
Then you file your written argument.
And may I only pray that, Lord, it may be taken up on 5th of December, my lord.
Okay.
So I'll not file written argument, I'll do verbally lordship.
No, you file your written argument, so cease the filing, and then we'll hear.
Can it be taken up on 5th
On
of
request
December?
made on behalf of Mr. P.K. Devari, then the senior counsel for the petitioner, list on 5th December.
Yes, my lord.
On the day you file your written
Yes, yes.
argument. That's
35 of supplementary list, hearing.
what is this? Oh,
Substantially had Mr. Das on the other side. He's not there today. If your lordship will take it up on next Thursday, it's not inconvenient.
Okay, on request made by the parties, we'll do that.
My lord.
Lordship.
Or you have some difficulty
No, I do not have any.
with being a central council. Sometimes.
That is what I was wondering, lordship. We'll just say simply heard and put it on Thursday.
Okay, heard Mr. B.K. Das, then counsel for petition, as well as Mr. R.K.D. Chowdhury, learned Deputy Solicitor General of India for the respondents. List the matter for further hearing. When do you want?
Tuesday I will not be there. If it is not inconvenient, lordship, next Thursday.
21st.
Yes, lordship. 26th. 21st or 26th, any day, lordship.
Okay, 26 is good.
Lordship.
Leave a short.
So,